Before we call upon the Solicitor General, as you know, that 2023 commemorates 50 years of the judgment in Keshwan and Bharti. On 24th April 2023, we had designed a web page putting together the relevant documents, introduction, the key legal issues, arguments, and the essence of the judgment in Keshwan and Bharti. I thought that to reach out to a wider section of our society, we should translate it into Indian languages. So, because language barriers prevent people from really understanding the work of the court. So now this video has been translated into to 10 Indian languages. You have them all before you. Of course, English, Hindi, Telugu, Tamil, Odia, Malayalam, Gujarati, Kannada, Bengali, Assamese, and Marathi.
I was waiting for Assamese, Milord. I was waiting for that.
So just a part of, and this is similar to our effort to translate our judgments into
this must be historic.
We have got about 30,000 judgments of the Supreme Court from independence until now, which have been translated now into Hindi. 20,000 have been uploaded in the ESCR. So district courts across India where work is predominantly carried on in Hindi can cite and refer to our judgments in Hindi, and this is being done in all the scheduled languages. But Hindi obviously was faster because we had some...
It will reach the much larger section of the society.
That's right.
Yes, people otherwise used to know about the Keshwan and Bharti case, even laymen, but without knowing that there was a big case, that's all.
Students, otherwise, for instance, who are not in the very highly resourced colleges, they can't even access our judgments.
Yes.
So now a student who wants to read a judgment in ESCR, in fact, I would request the members of the bar who would like to just spend 5 minutes, you can Google search for ESCR and Hindi and see, you have the same free text search facility in the ESCR Hindi as you have in English. So you want to sort of say land acquisition, Justice Surya Kant. It will give you the latest judgments or whatever, which you are doing in, as in the English.
India must be the first country to have started.
No other country has, we were talking to the Chief Justice who had come before us for the Nalsa event, and they were also saying that they will do this in their jurisdictions. So we'll start with
yes,
your side.
I filed this case law compilation in the morning. That's about 6 pages. I told your Lordship.
Yes.
I just prepared that. And only 2 more pages, Lordship may note, Lord, my written submissions of mine, Leonard and Mr. Samiran Sharma, which is in volume 1, page 183.
Yes. Mr. Sharma's submissions are in volume 1.
Volume 1, page 183.
Thanks.
And Lord, 180 is the submission of 3 pages of a junior colleague of mine, Lord Kavya Jhawar.
Page 180 of?
Of volume 1, my Lord.
Who's the colleague? Name?
Kavya Jhawar.
Yes, Mr.
There's a small note, additional note, Millers, which I'll circulate today. Millers is this, the expulsion act, Millers, which they submitted, which I'll validate today. And on Article 29, Millers.
Yes.
Just brief case.
Lord, I would respectfully begin my assistance with 2 very preliminary, Lord, factual clarifications.
Yes.
Lord, your Lordships are examining a limited question of constitutional validity of Section 6A, which by itself confined to very few individuals between a particular period of time. This examination has nothing to do with any other amendments in the Citizenship Act, so that there may not be any misunderstanding, deliberate or otherwise, and any further consequences. This is a very, very limited issue being examined.
Yes.
Lord, second, Lord, so far as the ground realities which are pointed out by the petitioners are concerned, that this influx of immigrants from foreign countries, they eat away, as to borrow their words, my Lord, the resources which were otherwise available to them. There are less opportunities, less job opportunities. There is demographic change, etc. Lord, all their concerns are true. The submission is declaring Section 6A to be unconstitutional is not the solution. There is a problem, there is a serious problem, there is an ongoing problem, but 6A is confined to a particular period of time, and declaring it to be unconstitutional would not be the solution of this problem. Now, my lord, I would first, my lord, start with Section 6A. Your lordships have read and reread, but I would respectfully urge your lordships to, my lord, go through it the way, my lord, I am inviting your lordships' attention to from that dimension, because some of the very important phrases, my lord, possibly were missed. But please see the title of the section. Special, your lordships have that.
Yes.
Special provisions as to citizenship of persons covered by the Assam Accord. Look, this is only for the purpose of one state, and I'll point out when I deal with Article 11 argument that there can be a special provision either dealing with particular set of circumstances, the situation prevailing, the peculiar situation in a particular state, etc., etc. So there is no gainsaying that you have applied only to one state. It is intended for one state. Now, please see the definitions, my lord, which are of very relevance when your lordship goes through how this section operated. Lord, first definition in Section 6A is Assam. Assam means the territories included in the state of Assam immediately before the commencement of the Citizenship Amendment Act 1985. So, my lord, whenever your lordships sees the word Assam in 6A, it would be without those parts who were earlier in Assam, like Mizoram, Meghalaya, etc., etc. So now we have a very limited geographical entity to deal with. Then second is detected to be a foreigner. My lord, there was some confusion on our side, my lord, that detected would mean ultimately declared by the tribunal. Lord, kindly see the definition. Detected to be a foreigner means detected to be a foreigner in accordance with the provisions of the Foreigners Act 1946 and the Foreigner Tribunal's Order 1964 by a tribunal constituted under the said order. So whenever your lordships, my lord, sees the definition of the expression detected to be a foreigner, it would mean a judicial adjudication after giving an opportunity that you are a foreigner. That is number two. Number three, and my lord, this is C and D, my lord, are more relevant. Definition is specified territory. Specified territory means the territories included in Bangladesh immediately before the commencement of the Citizenship Amendment Act 1985. So it doesn't talk of the entire Pakistan, what was Bangladesh as on 85. So again, we have a limited geographical unit, which is the subject matter of 6A. No, D again restricts, I'm sorry.
Yes.
The definition in D again restricts the application of 6A to very few individuals who will be qualified to take benefit of 6A. Please see, my lord. Person shall be deemed to be Indian origin if he or either of his parents or any of his grandparents was born in undivided India. As your lordships, my lord, goes through further, your lordships would find that 6A applies only to people who can fulfill this condition. So for getting advantage or benefit under 6A, I'll have to show that either I was born in undivided India or my father or my grandfather. So your lordships have three categories. First, the category in which it applies, the Assam, a very limited geographical area. The category from which the persons are permitted, only Bangladesh, a very limited area. And the persons who would be getting the benefit under 6A have to fulfill these conditions, and therefore very less number of people. It may be in thousands.
Now, how did the government, undivided India means undivided India as defined in the Government of India Act of 1935.
That is defined under the
2B. But now under the Government of India Act, undivided India comprised Pakistan,
Yes.
Bangladesh also.
Bangladesh was not there.
Of course, it was East
part of Pakistan. Yes.
Today's Bangladesh.
Yes, it was. Yes. Today's Bangladesh was a part of undivided India. But undivided India, my lord, is defined in the Citizenship Act itself.
It is. It's 2B. I think 2.
It's 2B.
2H.
No, I'm sorry. 2H. To mean undivided India as defined under the Government of India Act 1935.
Yes.
10E. A person shall be deemed to have been detected to be a foreigner on the date on which a tribunal constituted under the Foreigners Tribunal's Order 1964 submits its opinion to the effect that he is a foreigner to the officer or authority concerned. So there would be a judicial adjudication by a quasi-judicial tribunal after giving an opportunity of hearing, meaning thereby due process will be followed, and the person will have to now, this is a case where I want to be declared a foreigner. 6A are not the cases where people would be arguing, I am not a foreigner. People would be arguing, I am a foreigner and therefore I fulfill these conditions and therefore entitled to be a citizen. That's the distinction. This is a separate class by itself. Because I get benefit of 6A only if I'm declared to be a foreigner falling within the parameters of 6A.
Under the Foreigners Tribunal Order of 64, could an individual go to the tribunal and say that, well,
Yes.
now in view of this 85 amendment, declare me to be a foreigner?
Yes.
Or does a show cause notice have to be issued to him and
Both ways. Both ways. My lord, suppose somebody is, there is an apprehension that he is a foreigner. Then show cause notice would go that you are an illegal immigrant. He will go to the Foreigners Tribunal and say that I fulfill 6A condition and therefore I am a foreigner, but I am entitled to the protection under 6A. If he is not,
Before 1985, nobody would have gone to the foreigners tribunal and say, please declare me as a foreigner.
correct,
Because the consequence would be deportation.
correct.
So
Then
before the
nobody would have.
85 Act, there was no question of any individual going.
Correct.
But after the 85 Act, it becomes not a cause for deportation, but it becomes a cause for protection, grant of citizenship.
Your lordships are right.
So is there a provision by which an individual can go to the tribunal and then say, okay, please declare me to be a foreigner? Or how does it work actually?
I'll show that. But there are provisions under the Foreigners Act. He can go. But that was the root cause of the agitation which started. Because nobody was going for being declared as a foreigner because the result would be deportation. And therefore the influx created genuine concerns with the ethnic people. And that started. And the government was faced with a situation whether to accept the entire demand of the people of Assam or to permit everyone to come. And I'll show the government, somehow brought the issue down to a middle way. What they were saying was that whoever has entered after 51 should be deported. That was the demand of Assam Gan Parishad, Assam Students Union, etc. That was the demand when the government was negotiating. And therefore, this 66 deadline came into being. I'll show the history.
We would also like to know you may go about it in your own way. How are those dates taken? What is the logical basis for the dates?
There is
166 and
I'll just
23.
immediately answer that. I'll immediately answer that. The first date is 66. 66 is taken to be the date because on that date, an electoral roll was prepared containing names of everyone, whether disputed or undisputed, natives or illegal immigrants, and the elections took place in 67.
Is there any third category other than this? One is of Indian origin. One is other categories of foreigner. Could there be a third category?
My lord, in the context of this matter, there is none. Otherwise, my lord, there is a category of OCI, my lord, overseas citizens of India, my lord. But we are not concerned with that.
In that case, supposing if a show cause notice is issued, to issue a show cause notice, you have authority. That's number one. It should be followed by a final order. There should be some element of adjudication, though not by a tribunal, by the government, the government machinery. Suppose he doesn't go. He doesn't choose to go for the tribunal. What is his status? What is to be done for that person?
No, my lord. Then we will have
neither after show cause notice or after the decision arrived at by the instrumentality of the state. If that person continues to be there, or what do you do with it?
The deportation.
Then what did you do?
Detention and deportation. That's the statutory provision. Unless he proclaims protection under 6A.
No, he would acquire the status of foreigner.
Illegal immigrant.
That is what I am asking you.
Yes, my lord.
Could there be a third category there?
No, my lord. He would be an illegal immigrant.
Then if he's a foreigner, then he will go on before the tribunal.
No. Illegal immigrant also can go in. My lord, this is how it works. My lord, I can be a foreigner, my lord, if I go to US. I am going with a valid visa.
Therefore, there is another category called illegal immigrant.
That's the only category.
Now, that illegal immigrant will be declared as a foreigner.
Foreigner.
By the tribunal, correct?
By the tribunal, who deserves to be or who is required to be deported.
That's right. Thereafter, the scheme of the act will come.
Will come.
10 years and other things if he continues there.
Yes.
Now, supposing he says, yes, I'm a foreigner. There is a need for a determination by the tribunal in that case.
If he says,
you are also saying he's a foreigner, the tribunal will after adjudication of whole seems a foreigner, then he will get the benefit.
No, there are other conditions. For 6A, there are conditions. If my lord, suppose I am coming from Bangladesh and I admit that I am a foreigner.
See, the The reason there was a detection.
Answer that question. There would be three contingencies. I'll not say category of individuals.
Correct.
Three contingencies. A person comes with a valid visa. Valid visa would be a time period specific visa, the 6 months. We all go with a particular time visa. If person overstays, then he is an illegal immigrant as per the definition. Second, he comes without any travel document or any valid visa, then he would be an illegal immigrant. Third would be normal citizens, who have come, citizens from Bangladesh, who have come, but who claim benefit under 6A. For 6A, even if they are illegal immigrants at the time of entry, they have to fulfill certain conditions. So this is the third category. We are concerned only with that third category.
This exactly appears to be their grievance.
Yes,
Now, once you decide, once you hold, then after issuing the FOCA notice that you decide the status of person, there has to be a follow-up mechanism on that. Now, that is missing now.
No, my lord, follow-up mechanism under 6A is conferment of citizenship.
Now, question is, how many of those persons you deported now? Let us see how many of them are deported now. None. Maybe negligible or none. Now, they are neither here nor there, but they are enjoying the status of a citizen now. That is exactly the agreement.
That's not, my lord, with 6A. For 6A, that question doesn't arise.
That is actually the fault of 6A. Because there appears to be a huge gap between an action taken by an instrument of the state and the proceeding before the tribunal. There appears to be, there is a huge gap. Actually, it facilitates. See, one is on the challenge made by them. As we could understand from the argument, is on the effect of it is what they are saying. Now, what the situation as on ground is facilitated by the lacuna under the act. Because neither you push them to the tribunal, nor they are willing to go for the tribunal. This appears to be the case for maximum number of the persons.
No, my lord, possibly your lordships are, my lord,
and they have been allowed to continue.
Your lordships have, my lord, in contemplation, post 71, my lord, influx. Post 71 influx.
That's a different category.
Your lordships
Even pre 71. What my learned brother is saying is that there were people who benefited from the grant of citizenship by Section 6A, whether Section 6A2 or 6A3. Now, what happens to those who were not granted the benefit of citizenship, but they are illegal immigrants, and they continue to remain in Indian territory without the grant of citizenship, and nothing was done about them at all?
No, that is post 71 entrance.
Actually, Mr. Solicitor, there are two categories which 6A covers. One, people who came before 1166. Second, people who came between 1166 and 25,371. For those who came before 1166, there were two conditions. One, you must have come from the specified territory, namely that, the specified territory means
Present
Bangladesh. Second, you must be of an Indian origin. Indian origin as defined in the provisions of 6A1D, namely both your parents or any of your grandparents must have been born in undivided India. That's the second. And third, that you have continued to be an ordinary resident of Assam since you came before 1966. So 6A2 contained these three provisions,
Correct.
right? 6A3 covers the period 1166 to 25,371. That incorporates all these three conditions, plus a fourth condition, namely the
Tribunal.
condition of detection.
The
The requirement of detection was not imposed on those who came into India, into Assam prior to 1166. That was imposed for this group of people who came in between 1166 and 25 March 71. So the only difference between subsection 2 and subsection 3 is that subsection 3 imposes one more condition, namely the condition of being detected by the tribunal.
So the people who came between 51 and 66 remained without any adjudication. That's
They remained without
no,
adjudication.
that's the section. But that's
Elaborate further, this second category of person from 66 to 77, what the act actually contemplates is that all of them should be made to go for the tribunal, or machinery should have been developed by the government to make sure all of them shall get
yeah, lordships are right.
adjudication.
I cannot
It appears to be the objective.
dispute that.
That is
I
missing.
cannot dispute that.
It's missing.
I cannot.
That only triggered everything now.
In that sense, you have a larger group of people. What my brother is trying to point out is, I think,
Other than 6A.
that you have a larger group of people who came from the specified territory. In that larger group, a smaller group of persons who got the benefit of 6A by actually becoming citizens.
My lord, that was a part of the settlement which resulted into, my lord, a legislative enactment. That's the position. But foreigner tribunals are, my lord, functioning. Maybe number of foreigner tribunals are required to be increased. My lord, the space requires to be increased, and for post 71 influx, my lord, the steps need to be taken. My lord, I'm not shying away from.
Though the analogy is not exactly correct in this case, in Ramanohar Lohiya, Chief Justice Hidayatullah gave the example of concentric circles. Concentric circles. You know, the bigger circle, the smaller circle.
Yes.
Now, in this case, the bigger circle, to use Justice Hidayatullah, Chief Justice Hidayatullah's analogy, the bigger concentric circle consists of people who came into India from Bangladesh between 66 to 71. The smaller concentric circle within that larger concentric circle is people who get the benefit of citizenship under 6A. The area between the larger and the smaller circle is of people who came in between 66 and 71, but never got the benefit of citizenship.
No, my lord, they would get 66 to 71. They would. Get.
Everybody didn't get citizenship.
So they would, my lord.
No, everybody qualified to get citizenship, but everybody didn't get citizenship as a matter of fact. Because unless there was a detection order, you wouldn't get citizenship.
Yeah, correct. Well, no, the detection. Yeah, I understand the point.
Therefore, between that smaller circle and the bigger circle, there was a group of persons who had come, who were still in India, but never got citizenship.
My lord, I'll add one more.
What happened to those people?
No, my lord, I'll just say. Everyone who came between 66 to 71 will have to be given citizenship if declared to be foreigner by the tribunal. The problem is, if the tribunal takes a little longer decision, my lord, for declaration, or either way the tribunal decides whether you are a foreigner or you are not a foreigner, and there is a challenge to the High Court, to this court, remand, etc., my lord, then that period, my lord, they are not getting the citizenship because it has to be dependent upon a final adjudication that you are a foreigner.
Because the difference between subsection 2 and subsection 3 is, under subsection 2, Parliament decided that anybody who came before 1166 would become a citizen, subject to fulfilling three conditions: Indian origin, specified territory, and ordinary residence.
Correct.
All right, once you satisfied it, there was a deemed conferment of citizenship. 3 does not do it for those who came in between 66 and 71. 3 says detection by a tribunal is necessary.
Correct.
Now, where there is a detection by the tribunal, those people would be conferred citizenship under 6A3. They get citizenship. What happens if those who never got the benefit, because then their status...
Never got, my lord, may not be correct.
So tell us broadly.
Okay, can I, my lord, take your lordships the way
The figures.
6A I read?
The figures. How many people got the benefit of 6A2? How many people got the benefit of 6A3? And third, to complete the trajectory, how many people actually came into India between 1950 and 1970, 71 from the specified territory?
Look, some figures are available.
This appears to be the problem. Now, even for those who have come before January 1966, how do you determine? Now, this adjudication by the tribunal, declaring them a foreigner, this is again one job of the tribunal. See, now, tribunal has got ample power to say, this person has come and settled here before 1/1/1966. Therefore, then I am confirming that the deeming provision.
No, they don't have that power.
There is no adjudication. My lord, the Chief Justice is right.
So,
There is no adjudication. It's
now, you
confirmed
have
by
not
operation.
done that exercise. There must be adjudication on that. Okay, everybody would claim,
But
I have come before 1/1/666. How do you determine this? Now, all of them are immigrants and different periods, you have given a cutoff period. Now, unless there is a mechanism to deal with this, it creates total confusion. That's exactly what is happening. I would say that has come before 1/1/66, then he becomes a citizen.
Actually, conceivably, Mr. Solicitor, there may have been one, because there may have been one, you may be having the files and you may also guide us on that. People who came in between, we are now talking about the conferment of citizenship by an act of 1985, right? This all comes in 1985.
Correct.
Those who came in, say, between 1951 onwards, 51 to 66, the last of those immigrants had come in 19 years before the act was enacted. The first of those immigrants had come in 35 years before the act was enacted. So possibly, at that stage, Parliament felt that those who had come in that far back in terms of antiquity, somebody who came in 1951, to ask that person to prove X, Y, Z was perhaps humanly impossible. Therefore, Parliament possibly made a classification that people who came in before 1966, because 66 is a very watershed, it's a watershed moment. 66 is a watershed moment because the electoral roll is prepared in 66, containing both illegal immigrants as well as our...
Presuming that he was ordinarily residing there.
Therefore, they said after 66, you must demonstrate that, you are detected to be a foreigner. Before 66, Parliament made, really, we must put it at that level. It was a policy.
It was a legislative policy based on the
policy that before 66,
Assam Accord.
In 1985, to tell a person that you show us what were your documents in 1955 would be humanly impossible. 35 years later, who would have any documentation to show that he was in Bangladesh? Many of those people may have died. Their children may have been involved, or those people, their grandchildren may have been involved. So possibly this was a sort of we are trying to assess what was the reason for
possibly, my lord, because it's not, my lord,
that's
coming.
Why the distinction between two, because before 66, possibly Parliament thought it's impossible to go into these facts.
Possibly, my lord, the person's name being included in the voters list was taken to be a prima facie evidence that he has been ordinarily residing in India. And, my lord, based upon which Assam Accord, my lord, was made. That, all right, 51 to 66, since your names are there, don't give any proof, you will be conferred with citizenship. But 66 onwards, you will have to establish that you came from Bangladesh and you are entitled to the citizenship, for which, my lord, 3 conditions are laid down. And dates are, my lord, taken from the Assam Accord, and the relevance of the date, my lord, I'll just point out. My lord, first is, my lord, the date of 66, 1st of January 66. My lord, the reason is, on that day, the electoral roll for the election of 67 was published. So whoever is there in the electoral roll was possibly presumed to be ordinarily residing and must have come prior to 66. That is number one. Number two, my lord, the second date is 25th of March, 71.
That is the date on which 26 is when Bangladesh declares independence.
No, my lord, Bangladesh declared independence on 26th.
That's what I'm saying.
Yes, my lord. But our date is 25th.
Right. That is the eve of the declaration of
No, my
independence.
lord, there is a reason, my lord.
What's the reason for that? Tell us.
Yes, my lord. Yesterday we, my lord, tried and found out. My lord, on that, there was a communique by the then Honorable Prime Minister of Bangladesh, Sheikh Mujibur Rahman, to the Government of India.
Just 1 second, we'll take it down. To the Government of India.
Yes, my lord. It's communique.
This is 8 February 70. Oh, this is 8 February 72.
72. But there is an undertaking given, my lord, which is mentioned by him, my lord, in this. My lord, please come to the second page of this document.
It's at page 9398 at volume 4A, this communication.
What is the page, Mr. Sibal?
398, volume 4A. It's mine.
939.
Yesterday.
9398.
Volume.
If any of the juniors can
Four.
just check the page and see there.
Yes, I'll just, my lord.
Any junior on both sides can check it for a minute. In case there is some error.
9398.
It's a joint communique based on the end of the.
Yes,
visit of Prime Minister.
correct. This is the one.
So the refugees.
My learned friend
It
is.
appears that the refugees started coming around the 25th of March into India. So this is all history. What happened? What is the trigger for 25th of March?
No, that is mentioned,
Because
my lord.
I saw that the Prime Minister of Bangladesh solemnly affirmed his resolve to ensure by every means the return of all the refugees who had taken shelter in India since 25 March 1971 and to strive by every means to safeguard their safety, human dignity and means of livelihood.
Yes, but
What was the trigger? You just find out. I'm
No,
sure
the
you can do a
Honorable
little
Prime-
search in history. What was the trigger in Bangladesh on 25 March 1971? Something would have happened in history.
Lord,
There must have been some
Lord, I'll
incident.
just
There
say,
must
Lord,
have
this
been.
is not on record, my lord, but I must assist your lordships correctly the way I am instructed. Lord, there was a direction by General Yahya Khan that on 25th of March 71, there would be Operation Searchlight. So meaning thereby, my lord, an invasion or attack on the Bangladeshis, my lord. That was the date. That date is confirmed. That date is in public domain. And therefore, possibly the Prime Minister, Honorable Prime Minister, my lord,
It is Operation Searchlight.
Operation Searchlight, and therefore the Honorable Prime Minister of Bangladesh said that on 25th, thereafter, we'll take everyone back. It was a solemn assurance given by the sovereign of one country to sovereign of another country.
I'm sorry to interrupt, Malaj, my learned friend permit me. There's a Bangladesh Citizenship Temporary Provisions Order 1972, which is 617 volume 4, which says that it shall come into force on the 26th of March 1971. And in terms of this, all those who are, all those whose father, grandfather was born in the territories now comprising Bangladesh and who were the permanent residents of such territories on the 25th of March 1971.
That's the sequel of communique. I was coming to that.
That's the.
That's correct. That's because of the sovereign assurance given by one sovereign to another, and that is how, my lord, the Bangladesh, my lord, passed this order. So that is 25th March, but the 25th March is historically, not, my lord, on record or official stand, was
Actually, you're right.
operations.
I was just doing a little Google search right now. It appears that Operation Searchlight by General Yahya Khan was 25th March 1971.
70. Lord, as a matter of fact, my lord, this was mentioned in the CIA's confidential report, which they declassify after 30 years. And that's available, my lord, even as a CIA report. Not that CIA's report is to be taken by the courts as a gospel truth. But there also, my lord, your lordship would find. That is the, my lord, relevance. Otherwise, it's an odd date. It can be 1st January or something. But 25th March had a significance, had relevance.
Yes.
Lord, now please come to subsection 2. Lord, I am trying, my lord, I am rereading section 6A only to point out that now, of course, my lord, this would have relevance on the statute book, but it has outlived its utility because nobody would be, my lord, alive who can, my lord, take benefit except, my lord, the progenies. But that is section 3, which your lordships would be dealing with separately. Please see 2. Subject to the provisions of subsection 6 and 7, not very relevant subsections, all persons of Indian origin. So first condition, who came before the first day of entry, so or January 66. So my entry should be before that.
Yes.
To Assam, meaning thereby the present day Assam. Even if somebody comes to Meghalaya, would not get the benefit from the specified territory. So not from anywhere in Pakistan, only from the Bangladesh part of the Pakistan, including such of those whose names are included in the electoral rolls used for the purpose of general elections to the House of People held in 1967 and who have been ordinarily resident in Assam since dates of their entry into Assam shall be deemed to be citizens of India as from the first day of January 66. Now, my lord, 85 and we are 40 years down the line. So first difficulty is, my lord, we are also not getting much, my lord, factual record, my lord, what was the reason, but appears to be, my lord, logically, that if my name is in the voters list, at least one fact is established that I was an ordinary resident of that area.
Right.
Whether I am originally Indian or I have come from that part of Pakistan which is now under 6A has to be Bangladesh.
Yes.
Then 3. Subject to provisions of subsection 6 and 7, every person of Indian origin, again, my lord, the same definition, who came to Assam. So, my lord, entry will have to be established on or after first day of January 66. So, after the voters list was over, post-voters list period, my lord. But before 25th day of March 71 from specified territory, so not from Pakistan, from Bangladesh, and, it is and, not or, and, has since the date of his entry into Assam been ordinarily resident in Assam. So, my lord, from the entry till the date of decision. So, not, my lord, few days stay. Continuous stay would be necessary and has been detected to be a foreigner. But to avoid arbitrariness, judicial intervention, findings by a quasi-judicial body, etc., my lord, shall register himself, he is not directly entitled, shall register himself in accordance with the rules made by the central government in this behalf under section 18 with such authority hereinafter in this section, subsection referred to as the registering authority as may be specified in such rules. And, my lord, now the fourth embargo, and if his name is included in any electoral roll for any assembly or parliamentary constituency in force on the date of such detection, his name shall be deleted therefrom. So, because he was disenfranchised. Those who came after 66, they were permitted to stay without any right to participate in the electoral process. That they got only after 10 years of this decision. Then explanation. In the case of every person seeking registration under this subsection, the opinion of the tribunal constituted under the Foreigners Tribunal's order holding such person to be a foreigner shall be deemed to be sufficient proof of the requirement under clause C of this subsection, and if any question arises as to whether such person complies with any other requirement, please note this, my lord, any other requirement. My lord, any other requirement means A and B, because tribunal would declare only C. The registering authority shall.
A and B, and also whether he is of Indian origin.
Exactly. I'm grateful.
The third, because that,
Yes,
that is
yes.
before A and B.
Yes, yes. If such opinion, that is tribunal's opinion, if such opinion contains a finding with respect to such other requirement, decide the question in conformity with such finding. Tribunal had the option to give that finding, then it binds the authority. But two, if such opinion does not contain a finding with respect to such other requirement, refer the question to a tribunal constituted under the said order. My lord, having jurisdiction, my lord, my book also had, my lord, typographical printing error. My lord, everyone, my lord, we have this problem. This, my lord, of Bare Act, my lord, contains several printing errors. Your lordships, my lord, Bare Act also must be.
Yes, it's like that.
Having, my lord, this printing error. Order having jurisdiction in accordance with such rules as the central government may make in this behalf under section 18 and decide the question in conformity with the opinion. Then, my lord, registering authority, who is an executive, will not decide. He will refer it to the tribunal that, sir, you have not dealt with this other two conditions. Please deal with it. And, my lord, will act accordingly. A person registered under subsection 3 shall have, as from the date on which he has been detected to be a foreigner and till expiry of a period of 10 years from that date, the same rights and obligations as a citizen of
I'll tell you
India.
something very interesting. Even the India Code, I just did a search here right now. India Code, which is the authorized repository of Indian statutes, that also says hang jurisdiction. So it's not the private printers, the private publishers.
We have taken it from this official version.
Professional as well.
Correct.
He is right, my lord. Universal has, I didn't want to name the publisher, but Universal has this mistake.
The repository in India.
So, my lord, the political solution, my lord, of a problem, sometimes executive, my lord, is confronted with some problem which needs to be resolved by using legislative means. My lord, there was that, all right, your argument that from 51 onwards, everyone should not get citizenship, you come down to 66, my lord, which they agree. And from 66, the contention was that this large number of influx, and when I show the figures, my lord, the figures, my lord, the time at which the figures are shown, the population of Assam was, say, 1 crore, and the influx was 10 lakhs. So 10% influx, my lord, changes, my lord, right of political participation and right of political decision making, right of jobs. My lord, all of them didn't, after 71 at least, nobody came, my lord, because of any war situation there. Up to 71, it can be understood. Because of economic beneficial position in this part of India, in India, Lord, the land holdings were very wide, very huge land holdings. Lord, the population density was very less. The job opportunities were less. So they came for economic reasons.
They have challenged both subsection 2 and subsection 3, right?
Yes.
They are challenging the entirety.
They have
the
challenged
arguments seem to have been more focused on 3 by Mr. Diwan.
Yes, yes.
But the challenge
They have
to
challenged
the entirety.
They have challenged both, my lords. But I'm just, my lord, justifying this was, my lord, possibly because what my lord, transpired in the meeting between the Prime Minister and the ASU leaders, because I have read the Honorable Prime Minister traveled to Assam and held meetings, my lord. So this appears to be, my lord, a via media which is found out, that you don't insist on 51. You come down to 66. Then 66 onwards, we will restrict it up to 71, because 6A says whoever comes after 71 would be an illegal immigrant. No benefit, no nothing. Only foreigners tribunal would decide and you will be deported. But their contention that they are changing the political scenario, political representation, etc. Therefore, my lord, this via media was found that for 10 years, namely till the decision of foreigners tribunal is taken, you will not have a right of participating in the election. And that right came, my lord, only after 10 years of the declaration.
What's the date of the surrender of the Pakistani army actually, when Lieutenant General
Lord,
Niazi,
16th December 1971, General Niazi and
General Arora on our side.
and Jagjit Singh Arora on our side, my lord, and one Mr. There was a Christian fellow, Peter. No, Sam Manisham. General Jacob, yes, my lord, he was also instrumental.
He was Major General.
Yes. No, Major General was, my lord, Jagjit Singh Arora,
That's right.
but Mr. Jacob was, I think, my lord, he was, I'm sorry, I stand corrected.
Lieutenant General Jagjit Singh Arora, and if I'm not mistaken, Major General Jacob. Jacob was the Major General.
Jacob, my lord, he was, Jagjit Singh Arora was General Officer in Command of Eastern Command. GOC in command, as they say.
So interestingly, I mean, it may or may not have any bearing on constitutional validity. The cutoff date which is chosen, 25th March 1971, excludes all those who came in during that period of flux in Bangladesh, because the cutoff date is not 16 December 1971, it's 25 March 1971. So anybody who came in, that's right, that's what he just said. But therefore, anybody who came in after Operation Searchlight has been excluded from the benefit of such citizenship.
Yes.
So the Bangladeshi influx which took place as a result of the genocide in Bangladesh, they have been excluded by
because the Prime Minister of Bangladesh said that we will
compromise.
take them back.
They had a cutoff of 25th March 1970.
Because the Honorable Prime Minister of Bangladesh, my lord, said that we'll take everyone who came after 25th March 71
Back into our country.
back into our country. Lord, rest of 6 and 7, I'll just orally say, somebody can say that I don't want to get benefit of this. That's all. No, nobody is questioning 6 and 7. And Lord, it is very clear, Lord, from the section that after 71, all are illegal immigrants subject to being so declared by the.
Now we've got the statutory scheme. Now we can go straight to their arguments and address the submission.
Yes, my lord. Lord, if your lordship, my lord, there was a question, my lord, about Rule 19, that which came into force in 2013. My lord, I wanted to answer that question so that I can complete the chronology.
Yes.
My lord, your lordships have seen that 6A will be operated as per the rules framed under Section 18, my lords. Because, my lord, the first impression of everyone was that what happened till 2013. Even the rules are 2009. So there was no vacuum. My lord, that's all I wanted to say. My lord, nothing may possibly turn on that. But just to complete the history, my lord, and the chronology, my lord, Section 6A says that this process will be done as per the rules made under 18EE, small e. That is, my lord, confined to 6A. 18EE, my lord, if your lordships can see. It says 18, but EE, my lord, is, I have found, my lord. It's not entire 18, but 18EE was also, my lord, amended.
And that came in by the same amending act.
But yes, yes. Now, immediately thereafter, citizenship rules were framed in 1956, were amended, I'm sorry. Citizenship rules were already in existence since 1956, but they were amended to bring it in conformity with newly inserted section 6A. If your lordships would like to have the date, they were amended on 15th of January 1987 to give effect to, my lord, section 6A. That your lordships would find volume 4C,
With respect to rule two of section
yes,
6.
volume 4C, page 3,
Is,
page 3. It starts at page 3. I'm not, my lord, none of us either side, my lord, are required to go through 4C, volume 4C, Roman 4, Roman 2. Bro, please come to internal page 8, or my lord, PDF page 8. PDF page 8. 16 capital D was inserted.
Just a second.
Lord, your lordships may allow me to read, my lord, so that it would give, my lord, some assistance why 2013 amendment was required to be brought in. A reference to tribunals, where in the case of a person, your lordship, my lords, get
What,
this.
where are you
My lord
reading?
Justice
What
Paliwala.
are you reading from that volume 4C you're reading?
4C, para A, page 8.
Page 8.
These are the rules of 56, amended in 87 to
Oh.
deal with 6A situation.
16D आया था.
Where in case of a person seeking registration under subsection 3 of section 6A, any Lord, I may not read, but there is a reference provision because nothing turns on that. Then 16E is jurisdiction of the tribunal, which says that it would decide the reference under subsection 3 of section 6A. Last line, my lord, of page 8.
Yes.
Now, please see 16F. Registering authority for the purpose of section 6A3 and form of application for registration. Now, please come to 2, subrule 2. An application for registration under subsection 3 of section 6A of the Act shall be filed in Form 23 by the person with the registering authority for the district in which he is ordinarily resident within 30 days from the date of his detection as a foreigner, where such detection takes place after commencement of the rules, or within 30 days of the appointment of registering authority for the district concerned, where such detection has taken place before the commencement of the rules 1986. Well, there was a time limit prescribed for registration. If I am declared a foreigner and therefore entitled to the benefit of 6A, I'll have to get it registered within 30 days. Lord, the government, from the file, my lord, it appears, and I have, my lord, those documents also, that there were concerns that it is not possible to do it within 30 days. So though we are declared, we have a order of the tribunal, we are unable to get ourselves registered.
So therefore, then they brought in the 2013 amendment to rule 19. and said now 30 days after we issue this notification of these.
That's the reason, my lord. Just to complete, this is, my lord, the note of the then Home Secretary giving the justification for amendment in 2030. Nothing, my lord, may turn on that, my lord, but just to complete.
See, now we get some data. It is pointed out that on July 2012.
I read,
Right,
Lordship,
okay.
may not. It is pointed out that as on July 2012, 32,537 number of persons were declared illegal immigrants pertaining to 6671. No, there are other data also in my affidavit. I'll show, my lord. Stream by the Foreigners Tribunal. Of this, 12,914 number of persons have registered themselves with the registering authority. The remaining persons could not register with the registering authority due to variety of reasons, including expiration of limit of period of 30 days for registration. As a result, a number of cases have been filed before the Guwahati High Court indicating reasons as to how they could not register with the registering authority and praying that limit of the days for registration be relaxed. It would be difficult to repatriate or deport these category of persons to Bangladesh in view of the understanding between the two countries that persons who came to India up to 24th March 71 would not be repatriated to Bangladesh. Eventually, these persons will become stateless persons if they are not allowed to register with the registering authorities. This is a genuine difficulty being faced not only by the state government, but also by the identified persons. In view of the above stated positions, it is proposed that rules may be relaxed as suggested in para 5 of the notes on page 1920. N is note section. Your Lordship knows, my lord. So and so. So, my lord, this is how, my lord, the amendment came. First, my lord, 2009 rules came, and thereafter they were amended in 2013.
One very important circumstance which this note of the Home Secretary indicates is that, as we found from the joint communique which was issued in February 8, 1972, Bangladesh assumed unconditional responsibility to take back those who had come into India after 25th March 1971. Implicitly meaning, therefore, that people who had come into India prior to 25 March 1971, there was no question of deporting these people because Bangladesh would not be willing to take them back. If they were not conferred citizenship, they would be rendered stateless because they would not be going back to Bangladesh. And therefore, it was in that sense a solemn obligation which was undertaken by India in terms of an understanding with Bangladesh that pre-25 March 2071 would remain. And then we must also read it in the context of entry 10 of list 1, which says foreign affairs, all matters which bring the union into relationship with the foreign country.
Correct.
And therefore, the power under Article 72, the executive power would also extend to entry 10. So
Ram
this was,
Jawaya
in
Kapoor,
that
yes.
sense, an international understanding between the then Prime Minister of India and the Prime Minister of Bangladesh, that they would take back post 25 March 1971. Now, what would you do? These were not illegal. They couldn't be pushed out of Indian territory as illegal immigrants.
So extend the time and give them more time to get
Therefore,
themselves registered.
Therefore, the tacit understanding was that they would remain in India. You couldn't push them out back to Bangladesh because that was not the obligation which was assumed by Bangladesh. Therefore, instead of maintaining them as stateless persons in India, at least bring them into the mainstream by conferring the citizenship on them.
Just, my lord, as a
That seems
proposition
to have
of
been
law
the
doesn't arise here.
political compromise.
Doesn't arise here, my lord.
That's
Lord,
71, post 1971, there's no question of 6A doesn't
Even
confer.
Bangladesh agreeing to take them back,
Yes,
not
yes.
agreeing to take them back.
They don't have, they
They
don't
ag-
even
they
come
agree
in
to
the
take them
zone.
back.
They
They
agree
agreed to take them back,
back.
post 71,
Yes.
post the cutoff
And they
date.
don't
are,
even
yes.
come into the zone of citizenship.
That's correct.
Yes. So they are illegal immigrants.
That's correct.
And therefore, at some point, we'd like to know from the government, what is the government doing in respect of those persons?
Ye-
Because their
yes.
grievance
No,
in
that is
regard to
something,
those.
my lord, a really serious issue. We have said, my lord, what we are doing, but something more is required to be done. Because there is, my lord, demographic change and, my lord, there are several problems, my lord. Therefore, I started by saying that their concerns, their problems are not, my lord, I am not trivializing. I'm saying they are correct problems. I am only defending 6A, that's all.
That's
This limited
Because the
period.
communication, the Honorable Prime Minister of Bangladesh also acknowledges fact
Yes.
that there are scores of others who entered illegally thereafter.
Lord, whenever they say, whenever
Solemn undertaking
Bangladesh
was
say,
that they had been taken back.
no, whenever Bangladesh, the sovereign of Bangladesh says that before 25th March 71, we will take them back, it implicitly gives an assurance that after that, nobody will be permitted to cross over. That's how, Lord, the international relations operate.
Also, Mr. Solicitor, there's one other dimension that pre-25 March 1971 would comprise of two groups. People who have been granted citizenship, everybody before 66 becomes a citizen, right? After 1166, everybody qualifies for being considered for the grant of citizenship, provided conditions are met. Those who are granted citizenship would become a part of our mainstream. Those who are not granted citizenship, you can't push them out anyway, because Bangladesh is not going to take them back.
Then, my lord, it's not necessary for them, their agreement is not necessary. If they are not granted citizenship, it would not be possible, that contingency may not arise, because if he is unable to show that he is a foreigner, then, my lord, he is a citizen of India. If suppose somebody suspects that so-and-so is a Bangladeshi, I go to the foreigners tribunal and say, no, you are not a foreigner. That means I am a citizen of India. If I am a foreigner, before 71, I'll get the protection of 6A. And if I am declared a foreigner after 25th March 71, then I'll have to be, my lord, as per law, pushed back to Bangladesh.
Point.
My lord, please now come to, my lord, some facts and figures. Volume 3, my lord, the affidavit filed by State of Assam, it starts at page 969. My lord, there are several affidavits filed. My apologies. My lord, this is the affidavit dated 5th December 2014, page 969, volume 3. But there are several affidavits filed by both Assam, state of Assam, and the central government, but I'm not troubling your lordships with my lord, other contents, my lord, which are not 969. Affidavit dated 5th December 2014. Six nine six, 969. Now, the relevant part would be page 982. I'm not going to read anything, my lord. I'm just giving the details which were placed before your lordships. And whatever is relevant for the present purpose and whatever may answer my lord's very pertinent queries, my lord, I'll show. Because affidavits are very long affidavits, etc. My lord. My lord, now please see page 982. Your lordship gets, my lord, page 982. Number of cases, my lord, Chief Justice was. Number of cases before the Foreigners Tribunal and their disposals. The details of cases pertaining to January 166 to March 2471 referred to the Foreigners Tribunal between 86 to 31st July 2014. Because this affidavit is filed in December 14. The figures are as on that date. Total number of inquiries.
Volume 3.
3.
I'm sorry.
Page, PDF page 982.
PDF page, my lord, is 982.
Yes.
There is a chart, my lord, Justice Sundaresh. My lord,
Yes,
may
I
get.
Yes.
There is a hazy chart, my lord. It's a scanning of a Xerox, my lord, possibly. That's why it's hazy.
Yes.
Total number of inquiries initiated for period relating to January 66 to March 71. 52 lakhs. 5 lakh 20. 5 lakhs 20,438. Number of inquiries completed 5,22,326. Number of cases referred to the Foreigners Tribunal 42,000. Number of cases disposed of by the tribunals 31,105. Number of persons declared foreigners for period relating to January 166 to March 24, 32,969. Number of persons whose names were sent for deletion from the electoral rolls, the same number. My lord, your lordship knows they are disenfranchised from the date of the declaration. Total number of persons registered with the registering authorities, 13,914. Total number of persons declared as bona fide Indian citizens for period relating to January 166 to March 24, 71, 27,078. Total number of
Who got citizenship as of the date of this affidavit is about 27,000.
So, yes.
And 11,000 cases are pending.
11,000 cases are pending. And details of cases pertaining to, well, the difficulty is
71 and 8.
What about
that is next. That is next. My lord. That is, my lord, alarming, and next chart is not covered by 6A.
Tribunals are functioning.
Date on which it was inserted and came into force?
8
December
I just will achieve the
7/12/1985.
That is why they have taken.
7/12/85 minutes.
Part is from 86 onwards.
Yes. Now, my lord, the second chart, my lord, is little alarming. Details of cases pertaining to the period from March 2571 referred to the IMD tribunal. My lord, there were earlier.
There were tribunals, some tribunals were there.
Well, earlier, there was IMD tribunal, my lord, which was set aside in Sonowal judgment, with which your lordships are not concerned, but there was a tribunal. To IMD tribunal and subsequently transferred to Foreigners Tribunal after scrapping of IMDT Act. Well, scrapping means it was declared unconstitutional between 83 to July Day-31/2014. Total number of inquiries initiated on or after March 25, 71, 76 lakh 7, I'm sorry, 7,67,927. Then two, number of inquiries completed under IMD Act and total 7,44,820. Number of cases referred to IMD Tribunal or Foreigners Tribunal 41,000, 4,19,258. Number of cases disposed of by the IMD Tribunal or Foreigners Tribunal 1,87,294. Number of persons declared foreigners, illegal immigrants on or after March 25, 71, 35,000. Number of persons whose names were sent for deletion from electoral rolls 35,969. Then total number of persons declared as bona fide Indian citizens on or after March 25, 1971, 64,594. Lord, I'll just clarify this. Lord, they may be falling within 6A, but their decision comes late. Foreigners Tribunal, my lord, took decision late, or there may be a challenge before the High Court, Supreme Court, remand, etc., etc. The total number of cases where alleged persons are not traceable, that is 53,000. Because they enter from Assam and, my lord, spread all over. Mr. Diwan was, my lord, that's why pointing out that they have settled in Delhi. Some of them have, my lord, gone as back as far as, my lord, Jammu and Kashmir, etc. Then total number of persons deported, 2,447. Total number of cases pending before the tribunals, 2,31,000. This needs to be, now subsequent affidavit says that we have increased the number of tribunals, etc. But something more definitely needs to be done. I will not defend the undefendable. Now your lordships may come to the center's affidavit dated 5th December 14.
This affidavit of Joydeep Shukla is of what date?
5th December 2014.
Earlier one, which you showed us, right? Earlier one, the previous one.
That both are of the same date. 5th December 2014, and center's affidavit is 5th December 2014.
Where do we get that?
Same volume, 1182, PDF page 1182. I'll just glance, your lordships, take your lordships through, just glancing, just see the heading, that's all. Action plan for detection and deportation of illegal migrants in Assam and effective guarding of India-Bangladesh border. Then detection of illegal migrants, procedure for detection of pre-71, it's substantially the same we have pointed out. Procedure for I'm going fast, so that it's not necessary, therefore. Procedure for detection post-71, there are, what is the procedure put in place? Then deportation of declared illegal migrants, then strengthening of foreign tribunals. That your lordships would find at 1185. My Lord Justice Sundaresh.
Yes.
Then, my Lord, next page, detection of names of declared illegal migrants from the, deletion of names of declared illegal migrants from electoral rolls. Then, my Lord, National Register of Citizenship in Assam. Then effective border guarding for check and control of illegal immigration. It's a porous border. Now, my Lord, fencing is done. There is guarding. There is, light shades, my Lord, so that infiltration still continues, my Lord, which is being sought to be prevented. My Lord, rest, my Lord, is the steps which we have taken, my Lord, to ensure that there is less infiltration.
This data is of 2014. What is
Yes.
the present situation? How many matters are pending before the foreigners tribunals?
Lord,
We need that from the state of Assam. The Advocate General can give us up-to-date data. So that will indicate 2,13,000 cases were pending in 2,31,000 in 2014. What is the progress? How many have been disposed of? What is the action which we are taking? Because now post 71, 6A constitutional validity is one aspect.
Yes, yes.
But Mr. Solicitor, as you also say, what Mr. Diwan has argued, what Mr. K.N. Chaudhary has argued, and Mr. Ansaria, you are also not denying the gravity of the problem as it exists.
It is a serious problem.
So
Serious.
we want to know from the government of India, what are we doing now? Because this is not just about changing the demographics of Assam. That's one aspect, the cultural aspect which Mr. Diwan highlighted, but also the burden on the existing resources.
Sources, my lord, and those who should go to Indian citizens are, my lord, now being unauthorizedly shared by someone who comes only to share the resources.
People go from here to Mumbai.
Works because the affidavit says it is to be complete.
That also, my lord, I'll latest fencing work. Till date. There is one affidavit of 2018, my lord, but latest.
People got citizenship in the pre-1166 category. How many people have got citizenship, say, with the cutoff date as 1166? How many people have got citizenship 1166-25-371? And the third period is post 25-371.
When question of citizenship doesn't.
That doesn't arise at all.
Yes, I'll.
Because post 25-371, government has to be extremely serious about what is happening on the ground.
Yes.
They may succeed on their constitutional challenge, they may not succeed, but
This
what
is
they
a
are
serious
saying,
problem.
what they are saying has a great deal of substance, not only in relation to Assam, but for the rest of the country as well.
Because, Lord, they are not coming here because they are persecuted or there is some problem.
Yes.
Second. 6 to 7.
$1193 million.
Of how many people have entered post 25 March 1971? Approximately. Because do we have any estimate of that in India? Two, how many matters are pending as we post to the Advocate General? How many matters are pending before the
Tribunals.
tribunal? How many tribunals do we have? Because frankly, we will deal with the issue of constitutional validity, which is something which we have to consider. I mean, that's a very weighty argument. But assuming everything that we affirm the validity of 6A, what are we doing post 1971?
As a matter of fact,
One other aspect which you may consider See, our point also is that the very problems which the Solicitor General is projecting also happen in the context of Bengal, West Bengal.
We are going to come that. We come to that.
We are aware of it.
Also, when you're answering now, I think we've understood the broad lay of the matter. What we'd now like to know from you is the Article 14 argument, the cultural impact, etc. We'll hear you very briefly, but your point really will be that, look, this was basically political policy, and therefore this is something which is factored in. But we'd like to hear you on that.
I'll
But
just
most important, why did you single out Assam when we found yesterday that West Bengal shares a much larger border with Bangladesh, and therefore, presumably, the extent of illegal migration into West Bengal would be as or even more significant? Or did we have any cogent data to indicate that the extent of illegal migration into West Bengal was minimal as compared to this? Therefore, we left it alone.
No, my lord, we don't have. And this is the answer which I am going to give, my lord.
Now, what my lord is saying is that now, after Assam, this illegal immigrant will get into more and more they get into West Bengal now.
Absolutely.
What is going to see? Therefore,
It's
we want to
going
know
on.
how do you propose to deal with this? At least after 71, after 71.
And Mr. Solicitor, there are a couple of, we have to look at it at different layers. First, there's a layer of legality, that we deal with these illegal immigrants who are here with due process of law, because we are not some authoritarian country that you just pick them up and treat them, and show the power
due
of
process is the tribunal.
We have to follow process of law because we are a democratic country governed by the rule of law.
Correct.
And there's a grave danger that you might actually pick up. If you don't follow the rule of law, genuine people may be picked up and thrown out. That's something we must also.
Yes, sir.
But more important than also, what are we doing from here
Onwards.
for the future? What is the government of India doing in terms of ensuring that you have an impermeable border? How much investment is the government of India taking into ensuring that the border becomes, in that sense, impermeable?
Lord, I understand.
What are the executive steps which the government of India is taking? Have we, to what extent has the border been fenced? We understand that the terrain is impossible to be fenced also, but what are the steps we want to know? Because this is a crucial problem, independent of 6A.
1126, my lord, may give some answer, my lord. Lord, this is again as of 2014. This is regarding border fencing, my lord, Justice Suryakant's query, my lord. My lord, apropos, my lord, yes, my lord, that is given, my lord, in the affidavit, my lord. Yes, my lord. What is the process? What is the procedure followed? That is undertaken, my lord. That is undertaken. They are being subjected to the Foreigners Tribunal jurisdiction. The data, my lord, we will provide.
As government of India, does government of India have data? And Mr. Solicitor, we understand the problems of all this as well, because culturally, you're dealing with people who look exactly like you, they speak the same language, they dress the same way.
No.
What is the data with the government? What is the extent of the illegal immigration post 71?
My lord, I'll just, my lord, point out.
Do we have that data?
No, this is my answer, my lord, not the government's answer, my lord, because I could not, my lord, get it from the record. So far as Bengal is concerned, my lord, the general discussion which I have with the officials is that Assam faced the problem and raised it at a level for the simple reason that culturally, Bangladeshis and Assamese were so different that it was easy to identify. In case of Bangladesh, their language, their food habits, their dressing, everything, they mingle very easily, number one. Number two, because of that, maybe there is no uproar or something, but that does not justify the government not taking steps. I must admit.
Correct. With great respect to my learned friend, regarding races, there are a lot of differences in judgment. One can make out.
Between?
Not predominantly Assam is a.
No, he is agreeing with you. He's saying
I'm
supporting
supporting.
He's talking about Bengal, not Assam.
I'm talking about Bengal.
Bengal. That's why I thought I'll clarify. I got your point. We realized what was in your mind. He was talking about Bengal. But now tell us, what have we...
What I'll do is,
Look, one way, Mr. Solicitor, their argument is strike it down under 14. You didn't do to West Bengal what you have done to Assam. You have an equal illegal immigration into West Bengal. You've just let it be. Let it be in the sense they are liable to be deported. You granting them legality in Assam. One is the 14 argument. But beyond that now, we are going beyond the validity argument.
correct.
What are we doing? Why? First, we want to know, what was the reason which prompted Parliament to exclude West Bengal from the grant of citizenship? We are not saying that they should have granted it. But why? What is it that led us to believe that this problem was peculiar to Assam and not to... Argument could not have been from the Indian perspective that there was an agitation in Assam.
Cannot. That can't be
The
there.
argument from the Indian
Can
perspective is
either
we have to do what is
justify-
good for the nation.
Yes,
Right? Why did we leave West Bengal alone? Second, what is the extent of illegal migration between 1971 onwards, and what is the position as West Bengal? And what is the government doing in West Bengal now?
I must admit, Lord, right now, my Lord, my preparation was on the validity part and legal part, but matter may not end today.
So we'd like...
Undertake to file an affidavit of the authorized officer, Lord, latest by tomorrow or day after, on all questions, because...
And we would like an updated statement from Government of India. Let the Home Secretary also apply his mind to this.
Yes.
What is the Government of India doing in terms of safeguarding the border, in terms of border fencing? What is the updated position? How far is the border fencing arisen? Because this is also crucial in the sense of, we get all these matters which come up before us every day about, the...
Foreigners Tribunal's award.
No, about the people seeking bail because they've been, when they've been caught, cattle smuggling, so-called cattle smuggling, involvement with the... We've also had cases, you will recall, of our own paramilitary forces officers being involved with that.
Yes.
Those people have been proceeded against.
Yes, sir.
So all this is a very serious problem.
My Lord, I undertake that Home Secretary will file an affidavit.
Bengal a party to these proceedings?
I think all states
All
are part.
states are right. You're a...
Well, state of Tripura also has equally same problem.
But
In fact, Tripura, it is find out-
one second, we will come to Tripura in a moment. Who's appearing for the state of West Bengal?
State is a party. Once
Have they filed an affidavit?
But
Have they
all
filed-
states are parties.
Mr. Diwan,
One of them.
Mr. Chaudhary, has West Bengal filed an affidavit in this proceeding?
I just check.
That is going to be a problem.
Lord, state is a party, my Lord. But I will, my Lord, I assure your Lordships, the Home Secretary will file an affidavit on all these concerns.
We would like to
Reason
have
is
an
this.
affidavit from them also.
The
From the state of West Bengal also, their official stand we want to know.
Certainly, my Lord. The reason is this, my Lord. Forget, my Lord, anything else. Your Lordships are a constitutional court, my Lord, protecting fundamental rights of every citizen. Lord, this would be a part of fundamental rights of large section of citizens, my Lord, in large, my Lord, in several states. where, their natural resources, their other resources, are being shared only on economic grounds.
Now, Mr. Solicitor, let's go rapid fire now on your argument to
Yes.
your response to constitutional validity.
Yes, kindly, my
You've
lord.
shown us the statutory scheme, right?
Yes.
Just tell us now what is your answer to the constitutional challenge.
Yes, my lord, please come to, my lord, my written submissions, volume 2A.
Volume 2A.
2A, my lords. And I'll, my lord, as your lordships have said, rapid fire, I'll skip, my lord, what is, they may be treated as read, my lord, but volume 2. Lord, to page 8. I'm skipping, my lord, whatever is not relevant immediately. Lord, enactment of section 6A, the history, the background behind it, my lord. There was a debate in parliament. Your lordships may not get much on that, my lord, except that I'll just, my lord, paraphrase so that your lordships may not have to read. Assam Accord provided and the government has agreed, that is one. Number two, at the relevant point of time, the war. And therefore, people have come. And most important, my lord, your lordships would get at page 10, because there was an argument of Article 11, my lord, that this amendment is virtually amending Article 4 and 5. Lord, that was 4, 5 and 6, I'm sorry, 5 and 6. Lord, that was, my lord, dealt with when 6A was being framed by the then Home Minister, my lord. Please see, my lord, page 9, Shri S.B. Chavan, the then Home Minister. Page 10, my lord. Page 10. Your lordship gets, my lord Justice. I am also referring to Article 11 of the Constitution, which clearly lays down that government is within its own powers to enact legislation conferring or terminating the citizenship, any of the rights which a citizen can possibly have. So this is a very wide power which has been provided for. There is no question of any infirmity under the Constitution or any other law for the time being in force. Lord, then your lordships can skip the rest. Then and come to, my lord, page 11.
That little part, PDF 2, of that part in the middle, we have made a commitment.
Yes, my lord, that's what I said.
That is a little important because
we have made a commitment to stop a large number of infiltrators who have been crossing over. The average rate comes to about 2,400 per month. All these people have been trying to cross, and we have been trying to push them across the border. There is no denying the fact that the people have come. Whatever Bangladesh government might say, I can say without any fear of contradiction that in fact, a large number of people have come. But they had come in a very peculiar circumstances, and that is why we could not possibly afford to take very harsh attitude, and that is why conciliatory attitude had to be taken, and that is why legislation is there. Lord, it says about pre-71, but admitting the position that this position has continued even after 71.
What was the statement of objects and reasons of the bill introducing Section 6A? What did the statement of objects and reasons say?
My lord, to give effect to the Assam Accord. I tried,
That's all.
but my lord, your lordship did
Nothing
not
beyond
get any
that.
assistance from that. Therefore, my lord, we tried and searched the debates of Parliament. Then, my lord, at the foot of page 10, the bold part, Sri Bhadra Pratap Singh, this unprecedented situation was not contemplated by 1955 Act. Therefore, this present amendment is trying to solve that situation, and Parliament is competent under Article 11 to enact this kind of a legislation. Then, my lord, Mr. P.A. Sangma's, my lord, is relevant at page 11. He was, my lord, MOS in Department of States. Members from this side and the other side, including, I think, Mr. Babul Reddy himself, have pointed out that Parliament is competent to decide on all matters relating to citizenship. And this has been very clearly, very expressly, unambiguously put forward in Article 11 of the Constitution. Therefore, the constitutionality of this bill cannot be doubted. The power of Parliament to enact such a bill cannot be challenged at all. My lord, on 11, let me, my lord, complete my submissions in 5 minutes. My lord, A. And my lord, there is a interesting Constituent Assembly debates when 11 was being framed.
Yes.
They say that we have to leave it to the Parliament. How? My lord, Article 4, Article
Why didn't you
5
formulate it A, B,
It is
C?
there, it is there. But, my lord, I'll just orally point out and then, my lord, show your lordships. Lord, Article 5 and 6 talks of deemed citizenship. That if you are born or if you have come before a particular date, Article 6 and 7.
6 and 7.
6 and 7, I stand corrected. Then you are deemed to be a citizen of India.
Yes.
That was when the Constitution was framed. Subsequent to the Constitution, there may be situations where the nation needs to confer citizenship on various other grounds or take away somebody's citizenship on certain grounds. And therefore, Article 11.
Acquisition and termination.
Yes. So, 6 and 7 are deemed citizenship when Constitution came. 11 is for future contingencies. Second, and my lord, this is on textual reading only. If 6 and 7 were to be frozen in time, as argued by the petitioner, then why have 11 at all? Then 6 and 7 is complete code. There cannot be any additional reasons for conferment of citizenship, or there is no provision for taking away citizenship.
To which their answer would be that Article 6 and 7 is Pakistan specific. That it basically deals only with Pakistan, right?
Correct, Manoj.
So the purpose of 11 is broader. 11 covers, but it will, Article 11 would not cover only Pakistan. It will cover the entirety of the
world. Well, there may be several citizens. For example, my lord.
The argument was that once, which you have to deal with, which is that once the date of 19 July 1948 is chosen in Article 6 for the conferment of deemed citizenship, then the argument was that you can't, by the exercise of an ordinary legislative power, reach that date of 19th of July 1948 because Bangladesh, 25 March 1971 and prior thereto, Bangladesh is a part of Pakistan. The area of Bangladesh now, specified territory is a part of Pakistan. Albeit is Pakistan. Now, therefore, the argument is that you can't, in respect of a period covered when the specified territory was in fact a part of Pakistan, can't confer by deeming citizenship, by deeming an act of citizenship, because 6A also is deeming
confer but not deemed.
You can't, yes, you can't, because you are making a deeming fiction. And that deeming fiction can't transgress the limitation which has been prescribed in Article 6. That's the argument.
The answer your lordships would get from the Constituent Assembly debates, which I have quoted, relevant part of only Article 11. Because My lord, the theme is
वो बंद कर दें उसमें
they won't listen to us. Why should they?
one answer to that which we put to them was that Article 6 deals with the position as of the date of the adoption of the Constitution.
That's
It
what-
basically dealt with the historical context of partition. Article 6, the answer probably would be that Article 6 does not tie down the hands of a future parliament to decide to
The
confer
contingency is not
in
contemplated.
Article 6. Article 6 can't be regarded as an exhaustive universe.
The
That would
reason
be
is,
the simple answer, I think.
your lordships would see Article 6, they say at the commencement of the Constitution. So, and they say very categorically while drafting the Constitution, while Article 11, that we may not be able to conceive of situations which might arise in future.
It's a declaration of citizenship for a group of people under the Constitution, that's
At
all.
that point of
That's
time,
over, that's
under
over.
those circumstances.
To accept their argument would mean that Article 11, the ambit would be to all countries other than Pakistan.
Yes.
Because that would be perhaps a very narrow reading of the power which is conferred by Parliament. Article 11.
Another thing, my lord, apart from the fact that Article 11 starts with nothing in the foregoing provisions,
It's a non-obstante clause.
Lord, initially when it was introduced as a draft, it said further provision governing citizenship, which was deleted consciously. But just give me 5-10 minutes. Can I please come
Where
to
is
page 12, 14 of my written submission. Lord, 13 starts with drafting history of part 2, entire part 2, but we are more concerned with Article 11. Lord, para 37. Does your lordships get it? 37. On 29th April 47, while moving clause 3, Sardar Patel requested that the following should be added to clause 3, thereby empowering the union. Further provision governing union citizenship may be made by laws of the nation. This was, my lord, the beginning of Article 11. This was conceived by Sardar Patel, my lords. My lord, thereafter, your lordships may, my lord, directly come to, Lord, it was referred to a committee. Please come to para 44. And the redrafted clause by the committee is, my lord, at para 44. It went before 3 different committees, my lord, this Article 11 issue. Thereafter, Sri B.N.
The
Rao,
constitution of the committee, it had Vardacharya.
my lord, all were eminent, my lord, please see.
Mr. Alladi Krishna, Alladi Krishna.
Kanayalal Munshi, K.N.
K.N.
Kaju,
Kashu, Munshi and
Munshi
Dr.
and Dr. Ambedkar himself. So we were fortunate to have, my lord, this constitution because of, my lord, people of this eminence and intellect. Then, my lord, what they suggested was every person born in India, in the union and subject to its jurisdiction, every person either of whose parents was at the time of such person's birth a citizen of union, and every person naturalized in the union shall be a citizen of union. Further provision regarding the acquisition and termination of union citizenship may be made by the law of the nation. Still further word remained, my lord. Thereafter, my lord, it was redrafted, and your lordships would find at page 44, para 3 only, my lord. Further provisions governing the acquisition and termination of union citizenship may be made by union law, that is parliamentary law. Then 45. Meanwhile, the Union and Provincial Constitution Committee at their joint sitting on June 5 appointed a subcommittee to consider in detail the effect of June 3 plan. My lord, that is Mountbatten plan. My lord, it's referred to as June 3 plan. The joint subcommittee met on June 8 and decided that the question of nationality and citizenship in the union should be re-examined by the ad hoc committee in light of the plan. In the report submitted by the Assembly on July 4, the Union Constitution Committee incorporated the citizenship provisions contained in the memorandum without any change, except that the word union was replaced by the word federation. My lord, your lordships can skip that. And my lord, please see the committees, my lord, is quoted, my lord. In this connection, my lord, page 16 top. In this connection, the committee quoted with approval the view of Calcutta Law Journal. It is not possible to define exhaustively the conditions of nationality, whether by birth or naturalization, by the Constitution. If certain conditions are laid down by the Constitution, difficulties may arise regarding the interpretation of future legislation which may appear to be contrary to or to depart in any way from them. The exact argument which is made. It would, in our opinion, therefore, be better to specify who would be citizens of Indian Union at the date when the Constitution comes into force, as in the Constitution of the Irish Free State, and leave the law regarding nationality to be provided for by the legislation by the Indian Union in accordance with accepted principles of private international law. But this gave birth to Article 11. But it is now in the evolution process, my lord. My lord, please see para 48. When the draft was presented, I will not read, but there were 140 amendments to the Constitution. Dr. Rajendra Prasad was pleased to say that you have it as a composite thing. Don't go one by one, but not relevant. Please come to para 50. Am I with you?
Yes, sir.
Para 50. The Constituent Assembly debates with regard to citizenship and especially Article 11. Lord, it was draft Article 6. So somewhere there would be a reference of Article 6, but that is present 11. Is illustrative and clearly points towards an overarching power being available to the Parliament. The following are the debates. Dr. Ambedkar, Mr. President, sir, except one other article in the draft Constitution, I do not think that any other article has given the drafting committee such a headache as this particular article. I do not know how many drafts were prepared and how many were destroyed as being inadequate to cover all the cases which it was thought necessary and desirable to cover. It is not the object of this particular article to lay down a permanent law of citizenship for this country. So it is very categorical. The business of laying down a permanent law of citizenship has been left to Parliament, and as members will see from the wording of Article 6, which is present earlier, my lord, Avatar of 11, as I have moved, the entire matter regarding citizenship has been left to Parliament to determine by law that it may deem fit. The effect of Article 6 is this, that Parliament may not only take away citizenship from those who are declared to be citizens on the date of commencement of this Constitution by the provisions of Article 5 and those that follow, but Parliament may make altogether a new law embodying new principles. They must not understand that the provisions that we are making for citizenship on the date of commencement of this Constitution are going to be permanent or unalterable. All that we are doing is to decide ad hoc for the time. I don't think with respect there can be anything more clear than this. Then, my lord, next Dr. Rajendra Prasad, my lord, only highlighted part I may read. I would therefore suggest that amendments of this nature might also be left over to be dealt with by Parliament at a later stage, and we might confine ourselves to the limited question of laying down the qualification of citizenship on the day of Constitution came into force. as my lord, the Chief Justice, my lord, said. Then, my lords, your lordships may kindly come to page 19. There are other, my lord, honorable members saying the same thing, but page 19 is Lord Dr. Alladi Krishnan, Sri Alladi Krishnan, Krishna Swami Iyer, my lord, at page 19, my lords.
Yes.
Sri Alladi Krishna Swami Iyer, the articles dealing with citizenship are therefore subject to any future nationality or citizenship law that may be passed by Parliament. Parliament has absolutely a free hand in enacting any law as to nationality or citizenship suited to the conditions of our country. It is not to be imagined that in a constitution dealing with several subjects, it is possible to deal with all the complicated problems that arise out of citizenship. Then, my lord, Hridaynath Kunzuru also, my lord, only highlighted part. There is nothing permanent about the qualifications laid down in Article 5 to 5C. I'm sorry.
Yes.
5 to 5C. Article 6, that is 11 present, my lord, slight modification that further becomes, my lord, nothing contained. Article 6 makes it absolutely clear that notwithstanding the provisions of these articles, Parliament will have power to make any provision with respect to the acquisition and termination of citizenship and all other matters relating to citizenship. Any defects that experience may disclose can therefore be easily rectified. The Parliament get experience, they need more qualifications, they need to take away citizenships, not concerned in this case, but generally.
Yes.
Sorry, I did something, yes. Lord, now, my lord, your lordships have, my lord, on the last day when my learned friend was distinguishing the judgment which I was to cite, have seen, my lord, at page 21, on interpretation of Article 11, that is, my lord, Izar Ahmed Khan versus Union of India. My lord, this is the judgment by 5 honorable judges, my lord. I'll read the highlighted part. It's, my lord, authored by my Lord Justice Gajendra Katkar. Lord, at page 21, bottom highlighted part. Article 11 confers and recognizes the power of Parliament to make any provision with respect to not only acquisition, but also termination of citizenship, as well as all matters relating to citizenship. Thus, it would be open to the Parliament to affect the rights of citizenship, and provisions made by the parliamentary statute in that behalf cannot be impeached on the ground that they are inconsistent with provisions contained in Article 5 to 10 of Part 11, Part 2. So clear that 11 is an independent power and it can add to.
Just read the next sentence also, in this connection.
Yes, I'll just, my apologies. In this connection, 246, it is important to bear in mind that Article 11 has been included in Part 2 in order to make it clear that the sovereign right of Parliament to deal with citizenship and all questions connected with it is not impaired by the rest of the provisions of the state part. Therefore, the sovereign legislative competence of the Parliament to deal with the topic of citizenship, which is part of entry 17 list 1 of the 7th schedule, is very wide and not fettered by the provisions of Article 5 to 10 of Part 2 of the Constitution. This aspect of the matter may have relevance in dealing with the contention raised by the petitioners that their right under Article 19 are affected by the impugned provisions, etc. So, my lord, this is the only judgment, my lord, on Article 11, but even textually and keeping in mind the drafting history, the only inevitable conclusion is that they say we cannot conceive of many future situations, we leave it to Parliament. So, my lord, this distinction between deeming or conferring, Lord, may pale into insignificance. My lord, page 24, your lordships may not read. I have just given, my lord, the words which are used in the Article 11 which starts with nothing in the foregoing provisions, my lord, are used only in these articles. My lord. So it is, my lord, elevated to that level. That's all, my lord. Nothing beyond, my lord, turns upon that. Lord, Article 324, my lord, my learned friends have not also, Lord, seriously pressed, my lord, so I'll not trouble your lordships with that. Please directly come to page 29, my lords. He also did that. My lord, Sarvanand Sonowal judgment, I have just said, my lord. Sarvanand Sonowal judgment was concerned with one act.
MDTR.
And the argument was that look at the serious situation on ground. This act does not fulfill the object it seeks to achieve. And on that ground, Sarvanand Sonowal was, Lord, declared, was pronounced, and that act was declared unconstitutional. It, in fact, supports that this is a huge problem. But your lordships are not, my lord, right now concerned with right, lord, legal correctness or otherwise of this judgment. Then, my lord, scope of judicial review in relation to treatment of foreigners, my lord, I may not trouble your lordships with. My lord, please treat this as read, my lord, because your lordships are aware of the settled propositions of law on this. Please come to page, Lord, 34. Lord, challenge concerning Article 14. Where I'll read, my lord, only one or two judgments, my lord. At page 35, this is a judgment by 7 honorable judges, special court bill. Only 71. There are numerous cases which deal with different facets of problems arising under Article 14 and which set out principles applicable to questions which commonly arise under that article. Among those may be mentioned the decisions of so-and-so, so-and-so. Then, my lord, highlighted part. But as observed by Justice Matthew, in the last mentioned case, it would be an idle parade of familiar learning to review the multitudinous cases in which the constitutional assurance of equality before the law has been applied. But, my lord, thereafter, my lord, at page 36, the Honorable Court, 7-judge bench, my lord, earmarks what are the contours your lordships would consider while, my lord, examining a challenge under Article 14. And relevant, my lord, all are relevant, of course, my lord, but please come to 5, just, my lord, at the foot. On the classification, my lord, my learned friend's argument was there is a classification. Well, I'm dealing with that submission, my lord. By the process of, your lordship gets that, my lord. By the process of classification, the state has the power of determining who should be regarded as a class for the purposes of legislation and in relation to a law enacted on a particular subject. This power, no doubt, in some degree is likely to produce some inequality. But if a law deals with the liberties of a number of well-defined classes, it is not open to the charge of denial of equal protection on the ground that it has no application to other persons. Classification thus means segregation in classes which have a systematic relation usually found in common properties and characteristics. It postulates a rational basis and does not mean herding together of certain persons and classes arbitrarily. The law can make and set apart the classes according to the needs and exigencies of the society and as suggested by experience. It can recognize even degree of evil, but the classification should never be arbitrary, artificial, or evasive. The classification must not be arbitrary, must be rational my lord, etc., etc. My lord, your lordships are well aware of the propositions, my lord. So I'll not, my lord, trouble your lordships with that. Please, my lord, come to the case of, my lord, Ajayab Singh, which is at page 38 at the foot, my lord, para 111. That, my lord, lays down substantially the same test. My lord, I may even, my lord, skip that. So please come to page 40. My lord, under classification. My lord, I'm duty bound to answer on facts on the question of Bengal. But my legal proposition, my lord, is this. And I will do that, my lord, in the within a day or two, by way of an affidavit filed by the Home Secretary. But the argument is, instead of 1, you should have done it for 5. So argument is of under classification. That may require law to be made for others, but would not be a ground to declare the law already made ultra-virus. Lord, first judgment is N. Venugopala Ravi Verma Raja versus Union of India. And please at page 41 see, my lord, the highlighted part. So under classification is always not a, my lord, ground of a successful challenge on Article 40. But the mere fact that the law could have been extended to another class of persons who have certain characteristics similar to a section of Hindus but have not been so included is not a ground for striking down the law. In treating a Hindu undivided family as a unit of taxation under the Expenditure Tax Act and not a non-Hindu undivided family, the Parliament has not attempted an obvious inequality. Then, my lord, Ajay Kumar Banerjee, only highlighted part, we may reiterate that Article 14 does not prevent legislature from introducing a reform, that is, by applying the legislation to some institutions or objects or areas only in according to exigency of the situation, and further classification of selection can be sustained on historical reasons or reasons of administrative exigency or piecemeal method of introducing reforms. Maybe for other states law may come, but that would not make 6A ultra-virus. So special provision for one state, historically because of Assam Accord, etc.
Yes.
Yes, but kindly, Ambika Mills, my lord, is a settlement. I'll not read that, my lord. Then territorial classification, your lordships would get, my lord, 43, page 43. Territorial classification is justifiable. Well, this is my submission in law. But factually, since it has fallen from the court, my lord, and the court, which is a constitutional court, taking care of fundamental rights of everyone present here or otherwise. Lord, I must answer the question regarding, my lord, territorial classification. Why not Bengal? Why only one state? Why not Tripura, etc. Lord, ODUL, my lord, your lordships are aware, my lord, I'll just read the highlighted part. Historical considerations and compulsions do justify inequality and special treatment. Then, my lord, next page, next para, highlighted part. And if after reorganization of states and integration of the PEPSU Union in the state of Punjab, different laws apply to different parts of the state, that is due to historical reasons, and that has always been recognized as a proper basis of classification under Article 14. Then, my lord, state of MP versus Bhopal Sugar Mills. Your lordships will come to next page directly, my lord, at page 44. The legislature, my lord, I'm reading the highlighted part. The legislature has always the power to make special laws to attain particular objects and for that purpose has authority to select or classify persons, objects or transactions upon which the law is intended to operate. Differential treatment becomes unlawful only when it is arbitrary or not supported that by a rational relation with the object of the statute. This court has held in several cases that where application of unequal laws is reasonably justified for historical reasons, a geographical classification founded on those historical reasons would be upheld. My lord, the same thing is, my lord, my lord, rest as settled propositions, if your lordship permits, I may skip, my lord, because just, my lord, your lordships gets our side of, my lord, judgments on one, in one submission, my lord, I have, yes. My lord, one last point, my lord, page 49.
Yes.
On classification where the law is made only for Assam. I'll just, my lord, paraphrase my submission, not going into it. There are several provisions under the Constitution of India which applies only to particular states, including the state of Assam. So there can be a law applicable only to one state. My lord, page 49, I have, my lord, pointed out the provisions which are applicable only to Assam. This is on, my lord, the classification based on territory.
Yes.
My lord, these are my respectful submissions. Only one thing, my lord, as a last thing, as I, my lord, I have some kind of an apprehension. My lord, I would request the interveners to keep in mind that they are here to protect 6A, meaning thereby they represent people from 51 to 71 and not post 71. So, my lord, their submission may not be such that though we are on the same side, I have to give rejoinder to them. That's all, my lord. I am
confined to the validity of 6A.
only validity of 6A.
Right.
Yes.
Mr. Attorney General, should we hear you right after lunch?
My lord,
Because we are
after
almost in the
lunch-
stroke of lunch.
After lunch, whatever details, my lord, I could get,
Yes.
I would submit before your lordships in 2 minutes, my lord. During lunch hours, we'll do that. And it would also be a part of my affidavit, which I'll file latest by day after tomorrow.
But in the event your lordships don't finish today, what is your lordships planning to do, my lords?
How long would you take, Mr.
Not very long, my lord. I think my
Mr.
learned friend
Attorney
has
General,
covered.
Mr. Attorney General, how long would you take? Because I think this has been covered substantially now. Mr.
I have
Sibal,
brief
about the
note.
same?
That's fine, my lord. There's no problem.
And, Ms.
I can
Jaising,
take very long.
Ms. Jaising, about the same time, I think?
About the same time as Mr.
All right. And then we can ask them to complete their rejoinder today then.
Just take a period of time. I have that one pager that my lords had said.
Fair enough, we can give you a one pager. So once,
Just summarize.
so what we can do is suggest is this. We start at 2 o'clock. We request all of you to, we have Mr. Attorney General, Mr. Sibal, Ms. Jaising. If you can conclude by, say, by 3 o'clock.
Not possible.
Mr. Attorney is saying 15 minutes.
I have a brief
15
note which I'll read.
Yes, say 10 minutes for the attorney, say 10, 15 minutes.
Whatever your lordship says.
So what we are saying, if you finish it by 3 o'clock, then we can give them an hour for rejoinder and then conclude the matter thereafter.
Anyway,
We'll see how it goes. We'll see how it goes.
Anything.
May I take your permission, my lord, to file a list of dates, reference to the compilation? It'll speed up everything because no one has really filed a list of dates.
Is it already? I just saw a list of dates in the attorney's written submission.
In my note there is, but I skipped it because that was argued before it.
Ms. Jessie, is your list of dates part of what you have filed in the soft form?
Compilation, no, it's reference to the compilation already filed. All the dates are available in the
Is
compilation.
your list of dates already in the electronic record which is made available to us?
No, my lord, not in the electronic record, it's culled out from the electronic record.
Then why don't you do this? Maybe over lunch, just the list of dates. You
Yes.
can email it to the court master. So you
Yes.
can then tag it as a volume. So all 5 of us will have it.
We can do that.
Because I have
And with
also
copy
just
to all of us,
response to my learned friend's argument, just made a 5-pager, Maharaj, that can be uploaded.
All right, then Mr. Sibal and Ms. Jaisingh's brief note, and anybody else who has that 1-pager, please over lunch, over lunch, give it to the nodal council.
Yeah.
There's a nodal council in this
Yes.
matter. Nodal council will upload it and give it to the court
Well,
master.
if I may be permitted to upload the one pager, not today, but tomorrow, because I have longer than one page, which I would like to edit down to one page. So,
That's a very fair suggestion.
Easy.
A brief note of over 3 pages, which
Yeah,
I don't even.
just to reduce the sense of stress of lawyers on both sides, because I believe in keeping my court stress-free. If your side can finish by the end of the day today, I'd said, 15 minutes, whatever. Between you, all of you can divide the time. No time for the Attorney General.
In fact, I'm not going to take much of a lot
No,
of
we
time.
don't set a time limit for the Attorney General in deference to your position. But if this side can finish today, I think that will be convenient for all of you. Your side will give you half a day on Tuesday. So by Tuesday lunch, we'll wrap up on this side so that you also don't have to, you have enough time to reflect on your rejoinder over the weekend.
Submissions we have got in morning.
No problem. So is that all right? I think we can then, yeah.
Entirely possible.
Yes, Mr.
No, I have a 2 or 3 page note. I don't propose to trouble your lordships in going to section 6A
Yes.
reading and all that.
Yes.
The entire case will, in a nutshell, will turn on how we construe Article 11. So once we have a proper comprehension of Article 11, everything falls in place.
Minutes. You can have a seat for 2 minutes.
Yes.
And we'll dictate a small order right now. Of course, the arguments are continuing because you said you'll file an affidavit of the Home Secretary on Saturday, but the specific aspects on which we want some, to the extent to which you have data, because obviously this is not it's not an affidavit of submission. We want something based on data. Factual, that's all.
For your lordship's assistance.
The provisions of Section 6A of the Citizenship Act 1955 can broadly be bifurcated in three time periods, colon, the period prior to 1 January 1966, semicolon, bracket 2, the period between 1 January 1966 and 25 March 1971, semicolon, and bracket 3, the period after 25, the period from 26 March 1971. Full stop. The above statutory provision has provided for the grant of citizenship to persons coming from persons of Indian origin, originating in the specified territory and who have entered in semicolon, who have entered India between the relevant statutory time periods, who have entered Assam bolo, and who have been ordinary residents of Assam after the date of entry. Full stop. The distinction between subsection 2 and subsection 3 of section 6A is that the grant of citizenship under subsection 3 is contingent on an additional condition, namely detection by the Foreigners Tribunal under the Foreigners
Act, 19.
Act or order. Under the Foreigners Order, I think. I'll just see that. Act, no? Under the Foreigners, yes.
Foreigners within
Foreigners
tribunals.
Tribunals Order 1964. Full stop. Upon being detected as a foreigner, subsection 3. I'm just going to say that. Upon being detected as a foreigner, subsection 3 contemplated that such an individual must cause to be registered in accordance with the rules made by the central government under section 18, into brackets, under section 18. Full stop. Subsection 4 of section 6A stipulated that such an individual would be entitled to the same rights and obligations as a citizen of India, but would not be entitled to entry in the electoral roll for a period of 10 years, upon the expiry of which the person registered under subsection 3 would be deemed to be a citizen of India for all purposes. Full stop. This court is in the process of considering the arguments challenging the constitutional validity of section 6A. Full stop. The third time period, this court is now, what's वहीं से delete कर दे. The third period is after 26 March 1971. Full stop. Section 6A, the provisions of section 6A make it abundantly clear that the conferment of deemed citizenship does not extend to such persons. Full stop. Next, this court is in the process of hearing the constitutional challenge to the validity, constitutional validity of section 6A of the Citizenship Act 1955. Full stop. While the arguments raising the constitutional challenge form the core of the controversy, submissions have been urged before this court in regard to the impact of illegal immigration into Assam, both on the demographics and the cultural fabric of the state. At this stage, you are the considered inter alia. There are other submissions which have been urged, including the validity of the provision on the anvil of Article 14, Article 21, Article 29A, Article 29 and Article 355 of the Constitution. Next. At this stage, we are of the considered view that it would be necessary for the court to have certain data-based disclosures by the Union Government in the Ministry of Home Affairs. So we accordingly direct that an affidavit be filed before this court by Monday. We'll say Monday because we are going to hear it on Tuesday so that you'll have enough time.
The Lordships may say before Monday.
On or before Monday, on or before Monday, on the following aspects. Bracket 1. The number of persons to whom citizenship, Manoj, Sundar. The number of persons to whom citizenship has been granted under the provisions of Section 6A, bracket 2, namely, with reference to the with reference to the time period of persons who came into Assam between 1 January 1966 and 25 March 1971, semicolon, bracket 2, how many persons have been detected to be foreigners by an order of the Foreigners Tribunal under the Foreigners Tribunal's Order 1964 with reference to the above period of 1966-71. 3, the estimated inflow of illegal migrants into India, including but not confined to the state of Assam after 26 March 1971. 25 to after 26, 25 goes up to midnight. No, so you say it has to be 26 March 1971. 3.
Before.
All right, 25th March, 25.
Is not inclusive.
All right, 25 March 1971. 3. 4. In respect of persons who are alleged to have entered India, including the state of Assam, after 25 March 1971, A, the total number of foreigners tribunals which have been set up by the Union Government, semicolon, B, the total number of cases which have been disposed of, C, the number of cases which are pending as of date, E, the average time taken for the disposal of cases, and F, the number of cases which are pending before the before the Guwahati High Court, before the Guwahati High Court ही बोल देते हैं. Then 4, the steps which have been taken by the Union Government at an administrative level to ensure to deal with illegal immigration into the territory of India from the northeastern states, particularly the state of Assam. Details shall be furnished in regard to the extent of border fencing which has been carried out and the steps which the Union Government intends to take with estimated timelines to complete the exercise of border fencing. Full stop. The affidavit, copies of the affidavit, soft copies, electronic copies of the soft copies of the affidavit shall be served on the counsel for the contesting parties. Anything else apart from this? That's
Directions.
but how many tribunals have been?
Yes. How many are functioning today also? As on date.
So we have then a clear picture of what infrastructure we have.
Only request is, whenever your lordships have said union government, your lordships may consider strong state government, because some functions are state government. I'm appealing for both, but.
All right. Where any of the, where specific aspects of the data which has been sought by this order require a disclosure, implicate the functions of the state government, comma, the affidavit shall be the data shall be shared by the government of Assam. Full stop. However, it is understood that a common affidavit shall be filed both on behalf of the Union of India and the government of Assam and the state of Assam, which are being represented by the Solicitor General and the Advocate. Right. Now, also, when we did we put the total number of persons who have been detected to be foreigners? Will I?
Would your lordships like to include Tripura also? That is another state
We
which
have
has
said,
been.
we have said,
Border states.
we have said all northeastern states, including Assam.
I'm
You
obliged.
have just said including Assam,
Man.
which makes it very clear. Yes, yes, Mr. Attenjan.
I don't take your lordships.
Neighboring 5 states
We
of.
have said all northeastern states. We have said all northeastern states, including Assam.
West Bengal doesn't come in northeastern state, that's the reason.
No, it includes.
Only
6
states
states
neighboring said enough. Otherwise, we'll have another dialogue started.
This will go far beyond 6A then. Yes, Mr. Attenjan.
No, I don't propose to take your lordship's time too much. I have prepared a note.
Let's
I think
quickly run through the note.
2C, I don't know whether there's a separate note. You got it?
Yes.
Yes, yes.
It's also on your screens, by the way. It's all on the screens in front of you also. The attorney's note, it's there as well. Yes.
I'll only invite Lord's attention to make note of a couple of paragraphs in his note. But broadly, the thrust of the submissions is this. What do we do? How do we read Article 11 of the Constitution? It's not proper to say that Article 6 will control Article 11. The plenary power of dealing with citizenship is in Article 11. And courts will always see that the plenary power is not curtailed. Correct? Circumstances which may come from time to time to deal with the question of citizenship. We have this whole Eastern European scene, Bosnia, Croatia, Serbia, very difficult, complex situations in dealing with migration of people. And therefore, Article 11 has been contemplated. I don't propose to read again those very important observations made by Dr. Ambedkar. And it's a bit of a headache for us to go plow through all these provisions. And therefore, Article 11 is such a plenary power, and courts will certainly give due deference to that, the way the plenary power has been exercised. I just make a note of that in paragraphs 13 to 16. On that aspect, we have paragraph 13 and 16, and Your Lordship, please. So if you therefore have this understanding of Article 11, any reading of Section 6A will fall within its scope. Any analysis of 6A. Also, just make a note of a few more paragraphs. Your Lordship will pass an order now, trying to look at the other questions, and that will address various concerns. So just make a note of paragraph 1, 2, and 3 in my note.
Yes.
No, I just less. So we're concerned with the question of addressing a state-specific resolution at a given point of time. So by a state-specific resolution, if the Parliament as a state did not probably at that point of time address some of the larger question, would not render that state-specific resolution as defective or illegal. So Assam Accord or a state-specific resolution necessitated by a certain set of events over a period of time.
Yes.
And therefore, the question of comparison with other states at that point of time did not arise.
Yes.
Then just make a note of another paragraph in my paragraph 5. Though this question has been referred to this bench on the question of delay in latches, so we not address arguments on that, but just make a note of it in paragraph 5. The Chief Justice yesterday made an observation about in 1985, what happened? You're looking 71 to 85. Look at the passage of time.
Yes.
Then paragraph 8, the other argument that the law became bad in due course of time. That principle was laid down in Motor General Traders, in the context of a rent control law.
Yes.
So I am not sure whether that principle can be applied in the facts of this case. It is not that 6A became bad in due course of time. And also next, in paragraph 10, the only difference between Article 5 and 6 is, just make a note of it in paragraph 10. The use of the words deemed is only to connote that those who fall under 6, 7, and much later under 11 shall also become citizens of India. Deeming is only used in this particular sense, shall also become citizens. The difference in 5 and 6 is from being citizens of India at the commencement of the Constitution, and those who come later from becoming citizens of India. That's the only difference. Therefore, nothing much turns on the use of the word deeming and how 6A tries to bring an amendment and articles and all that. So if you're right in addressing the court on the question that Article 11 is comprehensive to take care of any situation and 11 says make any provision. So making any provision is why.
Incorporated in paragraph.
I don't think I trouble your lordship's reading 6A and all that's been read. And if this reading of 11 is correct, then 6A is not only amply protected, but what Parliament can otherwise do under Article 11 is properly stated. And that will be my submission. Yes, please.
I won't take much of your lordship's time on this. Well, as my learned friends have argued on 2-3 counts. Number one, they say that their cultural rights under 21 have been impacted by this demographic change. That's one. Number two, that Article 14 has been violated for the reason that while this protection is given to migrated people in Assam, it's not given to others. And number three, they say that Section 5 and 6 are frozen in time in the Constitution. Article 5 and 6 are frozen in time. And therefore 6A cannot in fact have been enacted. Broadly speaking, these are the three broad submissions. Now, there's a fallacy in each one of them, and I demonstrated right away. Well, it's migration of peoples and populations is embedded in history. It cannot be mapped. No migration can ever be mapped. And if you look at the history of Assam, you'll realize that it's impossible to figure out who came when. Assam originally was a part of Myanmar. And it was way back in 1824, after the British Mullahs conquered a part of it, that a treaty was entered into by which Assam was handed over to the British. And I'm talking about 1826, 1824, 1826. You can imagine the kind of movements of peoples that must have taken place in the context of the then British Empire. And if you jump to 1905, you will have the partition of Bengal. And in the partition of Bengal, East Bengal and Assam became one. Indeed, at that point in time, Bengali language was forced to be taught in schools. There was a huge opposition to that. So this interaction between the Ahom people, who are the original inhabitants of that part of Assam that was taken away from Myanmar, integrated with the non-Ahom peoples. And therefore, the interaction and the absorption of the Bengali population in Assam has a historical context. In 1911, Malads, it was reversed. The partition of Bengal was reversed. But they belong to the same area. The ethnicity was different. The language was different. And all these problems were created by the British. Because when the independence of India took place, East Pakistan, which is now Bangladesh, was carved into a separate country. And the exodus happened because of the fact that the ethnic minorities, linguistic minorities, as well as the majority community in East Bengal, in East Pakistan was not willing to stay there. The problem on the West Coast was entirely different. On the western border was entirely different. Because on the western border, it was the Hindus who were coming into India, not the Muslims. The Muslims were given the choice to go there. That's why the date 19th of July. If you not come on the 16th of August, Mullahs, we are people who have been displaced from Lahore. My maternal grandparents were killed. So we came here immediately on the 16th of August. But there are many people, Mullahs, who came here afterwards. And they had to be given refuge. So therefore the 19th of July date, therefore the mechanism. That would never have happened in Assam. From East Pakistan, there was no such Mullahs. All the minorities wanted to come into India because it was originally a part of India, part of the British Empire. So when this partition took place, naturally, people of Indian ethnicity, Bengali ethnicity, their language would want to come. So, Mullahs, to try and argue a constitutional point, which is the point I'm getting at, to say that this has changed the cultural ambiance of Assam is constitutionally invalid. Because you cannot attribute to one event, this to one event. Nor is the court, Mullahs, has the wherewithal to do so. You shouldn't even start this exercise. More important, Mullahs, I have a fundamental right to move from one place of the country to another. So immigration or migration from one place to another is a fundamental right. Can some...
Within the country, of course.
It doesn't matter, Mullahs.
No, but within the country, this right really doesn't extend to people who are not Indians to enter.
Mullahs, but they were India. That's the point. They were Indians. On that particular day, they were Indians. When Mullahs, please, in 1971, when this happened, the war happened, Mullahs, and Bangladesh was created, they were Indians before that.
Who was Indians?
Mullahs, please, please.
No,
they were.
What's the argument?
Mullahs, what happened? Pakistan was created.
They were all part of undivided India.
Correct. They were correct, but they were
the government of India.
Correct. Mullahs, when Pakistan was created, naturally, people would like to come, Mullahs, in 1951. People would like to come, Mullahs. Bengalis would like to come. Hindus would like to come. That's the point I'm making, Mullahs. The constitutional, Mullahs, a constitutional argument can't be made because it happened in 1951 that they came here. Therefore, Mullahs, it changes the cultural environment of Assam. That's not a good argument constitutionally. For the simple reason, plus, the argument has to be applied in the context of demographic change. Demographic change can never be the basis of saying that my culture has been impacted. Can never be, as a matter of constitutional law. Why, Millers? Because Part 3 of the Constitution in enforcement of rights, Article 21 is the preservation of rights. 29 is the preservation of rights. There's a constitutional distinction between the two. They are people of different cultures, different traditions, maybe different language. They are entitled to preserve it. Nobody has infringed that. Their argument is it has been infringed demographically. An argument that has no basis in the Constitution. They have to show violation.
Mr. Sibal, there may be some problem with this because an argument about demographic change as affecting culture can never be made within the territory of India. For instance, somebody in a particular state, take for instance, there's this huge migration which is now taking place in our IT centers. People can't say our culture is being changed because of this huge migration.
See Maharashtra, Manas, labor coming from.
Because for the purpose of citizenship law, as Attorney General has very beautifully put it in his submissions, India is one entity.
Correct.
So no one state or no people in one state can say that, look, by virtue of the fact that we are having an influx from other states, that our culture is being affected. Too bad. That's what the Constitution presupposes by postulating Article 19(1)(d). You rightly said that, there's free movement. But this applies within the nation.
I agree. Let's kindly see 29 now.
Can the people of a state not say, suppose the union were to say that we are going to resettle, say 20,000 refugees or 25,000 refugees in a particular state. There may be substance in the argument, we may not accept it, but they can certainly found a constitutional challenge.
But I'll answer that. See 29.
We cannot have a challenge at all.
Well, that's 29. Just look at 29. Just have a look at 29. If I may, let's read it. Any section of the citizens residing in the territory of India, or any part thereof having a distinct language, script, or culture of its own, shall have the right to conserve the same. No problem. Which part of their petition says that their right to language, script, or culture has been impacted? That's not even their case. So how do you bring 29 into it? The submission that I am making is, this demographic change happened because of historic reasons. And these historic reasons don't relate only to 1947, after 1947. These historic reasons are etched in history, right from 1824. And it would be difficult for the court, bullets, to identify as a matter of fact that this happened only after 1947.
According to you, this flux was happening much before that.
Much before. It's part of history, Malad. And well, actually what happened in 1971 was the second partition of India. In the sense that Pakistan, East Pakistan was obliterated from the back, Bangladesh was created, and those people, those Hindus, and
that's not a second partition.
Second partition of Pakistan. So therefore, because of that, these people came across. It's that second partition of Pakistan that resulted in part of this influx. And
Parliament debated it, and I don't want to trouble your lordships. When Parliament debated it, Parliament said, we don't want to. Yeah. And this literature we've put in the compilation, Malaj. In our compilation, I'll not trouble your lordships with it. The point I'm making is Malaj, this second partition of Pakistan resulted partly in this influx. But the influx was happening, Malaj, all along. But in any event, Malaj, as a matter of constitutional law, they have to show as to what part of their language, what part of their script, what part of their cultural tradition is being impacted. And ultimately, what I heard the other side saying, and that's a political argument, what I heard the other side saying was, they have been even given the right to vote. That's nothing to do with 29. So, Malaj, what happened? Now, let's come nearer home, Malaj. Then what happened? In 1978, Malaj, the Janata Party came to power. And, Malaj, there was a Janata Dal chief minister. And, Malaj, as your lordship knows, Malaj, that government fell in 1979. Mrs. Gandhi then came to power. Now, what had been happening between 78 and 79, there were huge agitations in Assam by the student community. And if I may, Malaj, invite you, just note it, Malaj, there's a book called Modern Assam, which is part of the compilation, Malaj.
Where is that book?
Yes, give the page. Kindly, just at your leisure, read chapter 12 of that book, which is titled Waves of Popular Protest. Waves of Popular Protest. Just give the page, please, the PDF. It will give you the historical context of how this whole protest started. There was price rise, there was unemployment, and then part of it was attributed to the fact that there were people who had settled there since 1951, and there were protests against that. That look, these are outsiders, so these are the others. And the agitation reached such a crescendo that it led to huge violence. I mean, the Delhi massacre in 1983 was as bad as any massacres that have happened since. In fact, the agitationers said, we would rather give our blood, but we will not give our oil. Why? Because production of oil was in Assam. And there was they stopped the production of oil. Production of oil fell. Only 3 places they produced oil: Gujarat, Bombay High, and Assam. Transportation, was stopped. Killings took place. Children were killed. In 1983, Mrs. Gandhi decided to have an election. It was opposed. 2% of the people voted in that election. And a person with 17% won the election. There was again a huge protest. I'm talking about 83. Why this 85 happened? When Mrs. Gandhi was assassinated in October. The demand was that 1951 onwards, everybody who was a non-Assami who had come in should be thrown out. This was not agreed to. Mrs. Gandhi got assassinated in October 1984. Rajiv Gandhi then said, let's try and compromise this issue. In the meantime, Prafull Mahanta became the chief minister. And in the 2 years, 83 to 85, they got discredited. The movement, became weak. And the 85 Accord. Mrs. Gandhi always said, let's keep 1967 as the cutoff date. The learned solicitor rightly said, because of the 66 electoral roll. And 67 was the election. They did not agree at that point in time. But in 1985, when Rajiv came to power, he said, no, there should be give and take. And therefore, this cutoff date was agreed to.
And therefore, the 1966 to 1971 period was dealt with separately, and the other period was dealt with separately. That's the genesis. Now, Malas, the first submission that my learned friend gave, he gave you population figures, Malas. Those figures cannot possibly be relied upon one way or the other, because you don't know the genesis of the migration. And even their figures show that after 71, Malas, the Muslim population has been reduced. Therefore, Malas, yes, the rate of growth has been reduced. So the point I'm making is I'm on the first point, Malas, of the Article 29 point. Malas, that has no constitutional basis. But we're not talking about people coming from outside or coming from inside. We're saying that in any event, in terms of 29, you'll have to show infringement. And their infringement is only change of demographics. That's why they show the population figures. Change in demographics cannot be the basis of an infringement of Article 29. Cannot ever be. Unless, well, it's very interesting. In fact, if you ask me, Assam perhaps is the most multicultural, multilinguistic, the most diverse state perhaps in the country. And culture. Diverse culture. Of the 10 or 11 petitioners that my learned friend pointed out, each of them represents a separate culture. Nobody says that that's been infringed. That's not their case. So it's a very slippery slope to address this issue on the basis of demographic change. But this is the march of history. You can't stop this. And at that point in time, Parliament said, why should we stop it? These are our own people. For those Muslims who left India and went to Pakistan, and they wanted to return India, there was a whole different process. That's included in section 5 and 6, in Article 6. Whole different process. Because we did not want them back. Here we were welcoming them because these are people of our own ethnicity. So this was an act that was recognized by the then government and allowed to happen. But they did not realize the kind of opposition that will emerge as it did in Assam. It happened in other states, but it happened in Assam.
So essentially, the Assam Accord was that 71 onwards,
Yes.
Nobody will be protected.
Correct.
51 to 66 and 66 to 71, people who came in would be protected, basically.
That's right.
51 to 66, no questions asked.
Right.
66 to 71, you have to satisfy the...
That's correct. Now, if you look at really migrations this way, for example, when the Vietnam War took place, kind of the Vietnamese people that were settled, these are all foreigners. You look at the German the Turks who have now been given citizenship, when the Germany's tweaked its constitution. It's tweaked its constitution. It never allowed this to happen before. So Mexicans, there's a special provision of the Mexicans in the US. So the point that I'm making is that's the decision of the political process which allows this to happen and then makes a provision for it under the law. And there's no basis for challenging it other than the ground that it is discriminatory. But this was a non-discriminatory recognition. Not based on sex, not based on race, not based on caste, not based on religion, not based on on no prohibited...
Place of residence, yes.
Sorry?
Based on place of residence.
No?
You have to be an ordinary resident of Assam.
No, but that's the test. That's the test, Mullah. I'm sorry. That is the test. That test was applied between 66 and 71. And your lordship looks at the entry in list 1. It's entry 17 of list 1.
Yes, 17.
Which is citizenship, naturalization, and aliens.
There's no doubt that Parliament has a power. There's no doubt about it.
No, I'm
Entry
not
17
only... Sorry.
Entry 17 confers and read with 245, Article 245. Parliament undoubtedly has the power
Correct.
to legislate.
Correct. But they were not discriminating on the basis of residence. They were not discriminating anybody on the basis of residence. They were saying only if you are resident will you get this through the process of naturalization. So then under no prohibited category. And well, there's another very interesting feature as far as Assam is concerned. Assam has 5 hill areas, scheduled areas, that were created. And they are autonomous councils, Mullah. A lot of the minorities, Mullah, never went to those scheduled areas. You can't buy land there. So they remained where they are. So the Muslim population percentage showed it had increased. So all these are very complex issues, Mullah. How is this court going to determine all this and come to a conclusion that this is violative of 29? There's a place called Darang, Mullah. A part of Darang was created as a tribal area. So the Muslim population only stayed in the other part, Mullah, so that if you took Darang in its original state, Mullah, the Muslim population would be less. But when the tribal area was considered, the Muslim population would be more. The point that I'm making is there are no judicial standards to determine all this. It will be a hazardous task, judicial task, for you to come to a constitutional conclusion that because of this, their cultural rights under 29, because 29 is preservation of rights. Preservation of rights assumes that there is a violation, and because of which I have a constitutional entitlement to say, issue a writ of prohibition, issue a mandamus not to allow them to violate. That's nobody's case. And it is therefore not solely attributable to migration. So that's on the 29th. Now, it's absolutely tenuous connection, as my learned attorney says. Absolutely tenuous connection. One has nothing to do with the other. Very, very, very. Now, let's kindly come to now the Article 14 argument. That's even more interesting. Now, I'll assume, Malad, that 6A is struck down. Now, if 6A is struck down, what happens? Bangladesh will not take them.
As we said, this will result in a group of stateless citizens.
Total stateless.
The joint communique, which was issued by Sheikh Mujibur Rahman and the then Prime Minister, clearly says that Bangladesh will take back people who had come in after 25th of March 1970.
That's correct. So Malas, you cannot, as a matter of constitutional law, Malas, and again, if you go
So you will have people in India who have been otherwise recognized as foreigners by the Foreigners Tribunal's order, who cannot be granted Indian citizenship, and yet who cannot be deported, though they are aliens.
That's correct. And if you go to my submission, well, just give me power of judicial review. I've dealt with it in 2-3 minutes. I'll just finish on this aspect. Kindly come, alerts, to volume 2, my submissions.
Yes, we got yours. The ones, yes, we got your volume 2.
Volume 2. My submissions start at page 19, but scope of judicial review is at PDF 23. That's all right. In fact, may I tell you, Lordship, another thing. While this agitation was taking place in Assam, many of the people, whether Bengalis or others, moved out of Assam because they were fearing that they might be killed or hurt. Many families actually migrated to other states. So in fact, the migration to some of the other states, Malaj, is also attributable to what the uncertainty that prevailed in the state of Assam from 1978 right till 85. And then, Malaj, as your lordship knows, Meghalaya, Mizoram and others. So therefore, the Muslims the minorities would not have gone to Mizoram, Meghalaya and other places, Malaj. So it seemed that the population here increased in terms of percentages. So these are all very difficult aspects, Malaj, to analyze and come to a judicial verdict. So now if you look at Miller's PDF 23, if you just look at what Hannah Arendt said, right to have rights, that's the right to citizenship is the right to have rights. And I've quoted the page, I won't go to it, Miller's. And then your lordships will see laws should be interpreted, para 17. A, law should be interpreted in a manner that avoids rendering people or groups of people stateless. The international law norm against statelessness is to be found in foundational legal instruments, both see the Universal Declaration and the International Covenant of Civil and Political Rights, and Article 20 of the American Convention on Human Rights. And well as I've given some references there, your lordships may have a look at it. And the idea is that courts should attempt to harmonize domestic law with international law. That's Visakha Malaj has set that out. And lean towards upholding laws in cases where striking down would result in statelessness. And then citizenship laws should not discriminate on prohibited grounds. As citizenship is the right to have rights, and deprivation of citizenship renders individuals particularly marginalized or vulnerable. For reasons advanced above, courts should subject facially discriminated citizen laws to strict scrutiny. Is to protect individuals. So, Malas, this takes, and then Malas, somebody else in West Bengal or another state can say, you give me the same rights, but they cannot say, now you declare this as illegal, and therefore, where will they go? And Malas, the commitment to fence Bangladesh was made in 1985 itself. So 15 years and 23 years, 38 years have passed. The fencing has not happened. Should have happened. And this creates more problems for India, as your lordship said, because after 1971, what will happen? Children would have been born here. Can your lordships imagine the enormity of the problem? Those children born here would seek protection of 3. Where will they go? Into that, it's another area altogether. So that takes care.
Equally, there is substance in this grievance that, on the one hand, we don't have an open border.
Yes.
We do not say that anybody from Bangladesh can come and settle down wherever they want in India. At the same time, if we don't take action to curb illegal migration, then it causes all these problems in India. The feeling in India that, look, the infrastructure is limited.
Absolutely.
Education is limited.
Absolutely.
Public hospitals are limited.
Yeah.
We can't allow for an unlimited influx.
Absolutely. No, you're right. And this is the problem. Therefore,
we passed that order, which we did this afternoon. What are you doing today?
It's the executive that is to blame, Malaj. There's no doubt about it. And right from 85. And we create problems for ourselves. And then what happens is, Malaj, it becomes the other versus us. This is the heart of the problem. It is no longer a cultural issue. It's a political issue. Others versus us. Who gets power? Why do you give them electoral rights? This is the problem. Don't give them the right to vote. So therefore, you in the process are creating divisions in society, whereas your preamble talks about fraternity. Now, what is fraternity, Malaj? Live and let live is Article 21. Be and let be is secularism. That's what it is. And that's fraternity. And the entire argument on the other side is countering the concept of fraternity in the preamble.
So, Sibyl, how do you, I mean, this is not a question in the sense to tell you that you're wrong on this point, but just a little assistance. How do we sort of conceptualize subsection 2 of section 6A and subsection 3?
All right.
Subsection 2 deals with people who are in the electoral roll as on 1/1/1966.
Right.
They're all post 1951 people,
Right.
but who are in the electoral roll as of 1/1/66. That's why subsection 2 refers to the electoral roll of 1/1/66, 66 electoral roll.
Right.
The subsection 3 covers people who are not in the electoral roll of 1966.
Correct.
They came in later until 71.
Correct.
So what was the reason for protecting those whom they protected first in subsection 2? Was it that Parliament wanted to protect people who are, now they've come on the electoral roll as on 1/1/66, so we say, all right, you have now been assimilated. We have already, whether you are legal, illegal, we sort of make a blanket conferment of citizenship. What was why these two bifurcations into subsection 2 and subsection 3?
I will try and answer that, Malad. There are two reasons for it. Number one, even those whose names were in the electoral roll, people objected to them. People objected to them, saying they got themselves into the electoral roll. They did not come here prior to 1966. That's why the whole NRC exercise has taken place. And at the end of the NRC exercise, do you know what the result is? Your Lordship asked that question, they should have told you the answer. The answer is, today there are 19.06 lakh people who are left out of and whose appeals are pending. That's all. And the majority of them are Hindus. So it's not as if nothing happened after 71. This exercise has been done and done in 8 years, Malaj. Malaj, that's why Justice Gogoi said, everybody will have to produce the legacy tree, legacy data. Who was your great-grandfather? Even those whose names were on the electoral roll. So in the NRC, every citizen, every person in Assam had to face the test. So in fact, from a statutory standpoint, what my lord is saying is right. From the actual standpoint, it's just the other way around. Because there were thousands of objections. Well, somebody didn't have a school certificate. Well, who gave a school certificate at that point in time? Then you had to show, no, my great-grandfather lived in that village. Then there had to be a linkage document. Then you had to produce somebody from a nearby village or the village in which you lived. And he came and made a statement, no, his grandfather was living there. So, Malaj, it may be as a matter of law for you to say that's not factually correct. Well, the whole NRC exercise was that all this may be wrong. And it was monitored by this court. And it ultimately found that the majority of the 19 lakhs were Hindus. 1,600 crores were spent in that exercise. So the point that I'm making is, Malaj, while your lordships asked me that question, the factual situation is in fact just the opposite. Because I don't want to bring any politics into it, because everybody objected to a particular, that he doesn't belong here. Of course, that exercise is still going on. But Malaj, therefore, it would be dangerous, and this is my respectful submission, to move into areas where it's difficult to come to a judicial determination. That's why 6A was a matter of policy. It was legislative policy pursuant to a political accord which sought to maintain a status quo subject to processes for those who came between 66 and 71. Yes. And if they do not formulate how 29 has been violated, why would your lordships go into it? So, but that's really the answer to your lordship's question. That everybody was questioned. It just so happened that once you're on the electoral roll, then you have a leg to stand on. But that was not the end of the story. It's not as if everybody who was on the electoral roll was accepted as a citizen. And then, Mullah, the argument that they owed allegiance to Pakistan, I don't understand that argument at all, Mullah. When I am born, Mullah, do I have an oath of allegiance to give? Or if somebody is granted citizenship, well, people don't give oath of allegiance. When people came from what?
The upheaval, actually, as a matter of history, when did the upheaval start taking place in East Pakistan?
Upheaval started taking place in East.
No. The 66, I'm talking
Well,
about the leading up to Bangladesh.
Lordship knows, well, after the Bhutto election in particular, but the fact of the matter is that those belonged to an entirely different cultural tradition. This was all part of Bengal, Malad. This is East Bengal and West Bengal. So all this is the oppressive policies of Western Pakistan, so to say, or now Pakistan, right? And what is happening there to the Hindus today was sought to be done to the Bengalis. It's as simple as that. Who would want to stay there? But the impact of it, because they came this side, the impact of it was what happened in Assam later. But it's bound to limit resources. They were claiming that their education should be free. And then what happened? The tea planters came here much before 1951.
Operation Searchlight is initiated by General Yahya Khan on the 25th of March.
Yes.
Now, interestingly, Section 6A, 25th of March 1971, is not the commencement of the provision. It's the end of the provision.
End of the provision. Yes,
right?
Yes.
So, if at all, one would anticipate that the influx would take place around or after 25th of March 1971.
It didn't.
What the statute does is to go back 5 years to 66, 1166.
Yes.
What is the reason for that 1166?
As I told you, but 66 because of the electoral roll. After that,
the electoral roll of 1166, which was used for conducting the elections of 67, covered all those people who had entered India prior to 1166.
Yes.
Right?
Yes.
That is covered by 6A2.
Yes.
Just see how it is. I'll just tell you how 6A is worded. 6A2. All persons of Indian origin who came before the 1st of January 66 to Assam from the specified territory, now bracket, very important, including such of those whose names were included in the electoral rolls for the purpose of the general election to the House of the People held in 1967.
Correct.
That is to say, the 1967 election was held on the basis of the electoral roll of 1166.
Correct.
That covered people who had come in prior to 1166.
Not necessarily, people may have come prior, but they may not be in the electoral roll.
You're right. I'm not talking the exclusion.
Yeah.
But 6A2 covers people post 1166.
Yes.
Right? I can understand 6A2. 6A2 says, whoever now we have included in our electoral roll, we'll give them citizenship. Therefore, anybody whose name was in the electoral roll of 1166 got the benefit of citizenship, but under which provision? Under 6A2.
Yes.
Now, what is the logic for 6A3?
But I'm saying, many people who had come in even earlier, but they had no evidence to show. There are many people who came in earlier. No. A war is later. War is not then. It's 65 war happened.
6A2 you cannot justify on the ground of the Bangladesh liberation.
No, I'm not. There is a Pakistan war, Indo-Pak war of 65.
1965, there was a war.
There is the Indira Gandhi Pact. Chief and Indira Gandhi agreed. Pact. Those
election took place in East Pakistan. Mujibur Rahman won. There was it was unleashing of violence. He was not allowed to be sworn in. That's what happened.
70.
Yes, in 70, December 70. That's the violence that happened. He was not allowed to be sworn in.
But that is 3 months before our cutoff.
That's why, Malad, that's precisely why I'm saying, Malad, that 3 months has been also excluded, as your lordship sees now, from March onwards. Therefore, Malad, it has nothing to do, this exodus didn't happen from East Pakistan or Bangladesh at that point in time. This is all prior.
I mean, there's one way of dealing with it, which is that Parliament has legislative domain over what cutoff date to adopt.
That, of course.
Unless the cutoff date is palpably arbitrary.
That's correct, that's correct.
You normally allow Parliament.
But apart from that, Malad,
I mean, that can always be a judicial mantra, but we are trying to figure out what is the logic.
But Malad, it's not just a cutoff date. It is to prove, your residence.
Sorry?
It's not. That's all right. Said Malas, a person who got 17% of the 2% vote, Malas won the election. So that was rejected by the people. So it was, but Malas, the 66 onwards, you had to show evidence that you were resident for 10 years.
All right, Mr. Zibal,
So therefore, that's over.
Anything else?
No, I don't think so. I just want to. No, one second. I don't want to waste the court's time. Anything else? And therefore, there are only two aspects, the date and the territory. No, I don't think so. Also note, Miller, the tea plantations, the traders came much earlier. So the date and the territory are the two aspects, Miller, which are considered by and deeply obliged.
Thank you, Mr. Zibal. Yes, Ms. Jaising.
No, my lord is only confining to 6A. Why are you worried? They were worried they'll go beyond 6A. Of course not. We haven't argued that.
No, we are very clear in our mind. We have not heard the.
Because it has
Mr.
other
Diwan has not argued that. Mr. Solicitor has not argued anything beyond
Because 2024 is round the corner, Mullah, then nothing should be.
I don't think that this.
No, I'm saying.
2024 has no relationship with the constitutional being.
No, I'm saying nothing should be said.
But Mr. Sibal, equally, we must make it clear, you probably all have, you've got the drift of it, irrespective of what happens to 6A, and our minds are open until the last word is said by Mr. Diwan and the others. Irrespective of that, we intend, because it's a constitutional court, on what is being done to take care of the problem of illegal migration. That's something which I think we have to address in this judgment. And we do propose to address it because irrespective of what happens to their plea on 6A, I mean, the cause of the petition, there is a great deal of there's a great deal of substance in what their grievance. I mean, look, what are you doing to our state?
Therefore, I will not very categorically and candidly say that I am not trivializing their problem.
No, neither are we.
I am answering only the constitutional question. This is a serious question, and as a custodian of fundamental rights of all citizens, the Lordship.
We have to address that in any case.
We must, all of us must. No doubt about it.
Yes, Ms. Yes, Ms. Jaising.
May it please, my lords. My lord, I would like to take off from where Mr. Sibal left off. I think the question of plenary powers has been adequately addressed. I will not address that, except to say.
Request Mr. Sibal and Ms. Jaising to just indicate who they are appearing for.
Yes,
that we
I
have a-
want
Yes,
to
we have a
precisely
sense
that.
But I didn't ask you your writ petition.
Yes, my lord, I'll give you my writ petition.
My note, Mullah, who I'm appearing for.
My lord, let me give you my writ petition numbers. it's the very first one on board, 274 of 2009, which was originally titled Assam Public Works, now called INRI Section 6A. I'm appearing as an impleaded respondent in the first writ petition.
We do what we have done in the 370.
It's now called INRI 6A.
Apropos what fell from Ms. Jaisingh a moment ago, as we have done in the case of the marriage equality, Article
Yes.
370, can we call the judgment in Re 6A of the
Milord,
Citizenship
I would
Act?
agree with
Yes,
that,
yes.
respectfully agree.
So Diwan, I think
Yes,
that's already there. That's already there.
yes, it's already showing on the board as INRI 6A. It's showing on the board as INRI 6A.
So what is the submission?
But Milord, since the question has been asked who I'm appearing for, I'm appearing for an impleaded respondent in writ petition number 274 of 2009, which is the first item 501 on board today.
You are applying for the impleaded respondent.
Impleaded respondent in All Assam Minority Students Union is the name of the respondent. I am also appearing, my lord, for an impleaded respondent in writ petition number 562 of 2012. This is the petition in which the order of reference has been made to this court.
That
It's the
petition number,
reference.
petition number.
562 of 2012.
There again, you are appearing for one
For
of the
an
respondents.
impleaded respondent, impleaded by an order dated 23/8/2013.
Yes.
And the latter, my lord, is the one in which the reference has been made. Now, my lord, as I said, let me begin with where Mr. Sybil has left off. My lord, it has been said by academics the world over that the 21st century is the century of refugees and migrants. And if you shift it one century back, then the 19th century also was a century of refugees and migrants insofar as India is concerned. My first submission is that the Constitution of India bears the birthmarks of partition. And you cannot understand either the Constitution of India or the Citizenship Act without understanding what happened for almost a century before the partition occurred. And what led up to this partition. And the birthmarks are there in the Constitution. Article 5 confines itself to the commencement, as has already been said. 6 and 7 deal with migration to and from Pakistan. And the Citizenship Act deals with acquisition of citizenship after the Constitution comes into force. My submission is going to be Section 6A is a sui generis provision. And that's why it's called special provision. So it cannot be slotted either into the Constitution or into Section 4 and 5. Possibly it can be slotted into Section 7 of Article 7, a proviso. Because my submission is the proviso to Article 7 leaves the door open for further migration and does not freeze the cutoff date at 19th March 1947. 1948. There's no freeze to migration, or there's no freeze to granting citizenship to people who enter India after 17th March 1948. And that is obvious from a reading of the proviso to Article 7. I'll make good that submission. Then, my lord, I'll address a few issues on Article 29, because 14 has been adequately addressed, 11 has been adequately addressed. I will not cover the same ground. My lord, in my opinion, 29 has not been adequately addressed, and I'll attempt to do so. In fact, the Attorney General did not address 29 at all. I'm sorry, the Solicitor General made no submissions on Article 29. And my lord, from what I understood by the opening arguments of Mr. Diwan, his major focus was on 29. And that major focus was confined to demographic changes. Nothing more, nothing less. It was not his case that the script, the language, or the culture of Assam has been impacted. If it was, I have not understood in what manner. And may I explain, my lord, I would like to invite your attention to certain provisions of the Constitution of India. Assamese continues to be in the schedule of official languages of India. Point number one.
1 second.
Under the Constitution, adequately, completely protected. No question, my lord, of destruction of the language. Number two, Assamese continues to be the official language of the state of Assam. Remember, my lord, at one time, Mr. Sibal informed you that Bengali was forcibly made the language of Assam. That was reversed. And Assamese continues to be the official language of the state of Assam. Therefore, my lord, there's complete protection of language script.
Assamese is not the official language of the state. Bengali is also the official
Yes.
language of the state.
Yes.
And Bodo is also an official language.
Yes, my lord, I'm grateful for that information.
Assamese is the only.
My lord, I'm very grateful for that information because we are talking about a state which is bilingual. And therefore, my lord, what is the point of producing data to show the number of Assamese speaking people as against the number of Bengali speaking people in the state of Assam? It makes no sense. It's a bilingual state, a multilingual state. And as Mr. Sibal submitted, my lord, it is one of the most diverse states in the country because of the mass migrations that have taken place over the centuries, my lord, long before the Ahoms came to India, long before that. There has been migration into Assam. And this has led to the creation of a syncretic culture. No submissions were advanced on how the culture of Assam has been impacted. Now, my lord, a few more provisions of the Constitution of India need to be pointed out to see the special protection given to the state of Assam. First of all, under Article 342, the president of the parliament passes laws naming scheduled castes and scheduled tribes in different states. And my lord, I will share it with you because it's in the public domain. There is a law of parliament in 1976, which gives you the names of the tribes who have been put in the presidential schedule. The intention being to protect their culture. These are constitutional provisions for protection of culture, which are in place. Then, my lord, your lordship will turn to Article 244 of the Constitution of India. I'm going through the list of constitutional provisions which are intended to protect the state of Assam and in particular the tribals. My learned friend Mr. Devan said each of his petitioners represent a certain tribe. And I presume it was his case that it was tribal culture which is being destroyed. Now, my lord, we turn to 244 of the Constitution. Yes. Administration of scheduled areas and tribal areas. The provisions of the 5th schedule shall apply to the administration and control of scheduled areas and scheduled tribes in any state other than the states of Assam, Meghalaya, Tripura, and Mizoram. Special provisions have been made for these states given their history. Now, my lord, the provisions of the 6th schedule shall apply to the administration of the tribal areas of the states of Assam, Meghalaya, Tripura, and Mizoram. Then come to Article 244A, formation of autonomous states comprising certain tribal areas in Assam and creation of local legislative and council of ministers of both thereof. There again, my lord, there's a special dispensation for self-governance of tribal areas. One of the submissions made was self-governance is covered by Article 21. No attempt was made to justify that submission, but I'm giving you the answer. If self-governance is a right, yes, it is protected insofar as Assam is concerned in relation to tribals under Article 244A. Tribal areas have been put in a separate schedule which gives them autonomy of administration. Now, my lord, these are the provisions which conserve customs. And if custom and culture are synonymous with each other, then their culture is protected. Please don't understand me to say custom and culture are synonymous. They are not. But nevertheless, assuming for a moment that culture and custom are synonymous, my lord, they are adequately protected by the Constitution of India, and no case has been made out for violation of rights under 29, which was the major argument addressed by the opening argument. Now, my lord, this being said, please turn to Article 247. I'm sorry, it's not 247, it's 27. Yes, you have. Yes, he has.
At page
But read those
49, or
articles.
page 49 of the.
Yes, Lord, there is a list. There is a list, but I would like you to see the provisions of those articles, 275. 275. Well, Lord, your lordship talked about development. Here is the answer to development.
Already there, it's grants from the union to certain states.
Mandatory grants for Assam, my lord, not for the rest of the country.
Yes.
Please have a look. It is for what? For development. Mandatory. Whereas the others are at the discretion of the Union of India. When it comes to Assam, the word is shall, provided that there shall be paid out of the Consolidated Fund of India a grant in aid of revenue for the state of Assam, sums capital and recurring equivalent to ABCDE. Therefore, my lord, the brief submission that I'm making is that the Constitution adequately protects the right to culture of the residents of Assam. Now, my lord, I want to move to another issue. My learned friend used the expression throughout his arguments, indigenous people. Please note that the Constitution of India does not use the word indigenous anywhere. It uses tribes. I, for one, my lord, do not know who is an indigenous person of Assam. I don't know, because there is no legal definition of indigenous person in the Constitution of India. There is a definition of scheduled castes, scheduled tribes, and my lord, the rest of us who are citizens of India. So, my lord, kindly be a bit cautious about the use of the word indigenous. Instead, we can use the word tribes. The question then will be, is the culture of tribes endangered in any manner? And if so, by whom? Now, my lord, let's see the plain wording of Article 29. Just the straightforward reading. And my lord, it certainly surprised me. I don't know whether this court will be surprised. But in the last 75 years of the functioning of this court, I have been unable to find a judgment which defines what is culture. Or I was looking very hard, my lord, to see if I could find a judgment which I could present to you, which would precisely give you the content of the meaning of the word culture, so that it would enable us to decide when is it undermined. But there is none. To the best of my knowledge, my research could be limited, but this is my submission before you. Now let's read Article 29 and see what we can make out of it on our own. Without reference to any guidance from precedents. Protection of the interests of minorities. My lord, interestingly, the title of 29 differs from its content. Although it refers to interests of minorities in its title, in its content, it refers to all citizens, any section of persons. So the right to culture can be conserved by minority and majority citizens. So if you read it, any section of the citizens residing in the territory of India, it doesn't say any minority citizens. any section of the citizens residing in the territory of India or any part thereof, having distinct language, script, culture of its own, shall have the right to conserve the same. The next one, my lord, we are not concerned. It's about preserving educational institutions. It's nobody's case that any educational institution has been destroyed. So now, my lord, I would ask myself the question, how does one understand the word culture in Article 29? As I said, finding no guidance from the court, I tried to present something in my written submissions, culling out information from several authors around the world. And what we found, my lord, is that it is an expression which is notoriously vague. So if your lordship turns to volume 2, volume 2, page 74, under the heading Submissions to the Challenge Based on Culture. It is submitted that Indian culture, including Assamese culture, is syncretic in nature. For want of a better word, I use the word syncretic. Freedom of movement and residence and settlement throughout the territory of India effectuate and comprise part of India's syncretic culture and unity. But Lord, why do we have this freedom of movement across the country? In order to preserve our syncretic culture. We are allowed to go anywhere, do anything, and all our fundamental rights. Tomorrow I can migrate, but I don't know. Indian law does not recognize citizenship of a state. Let's be clear about that. We are citizens of India. And my lord, in answer to the question, why is ordinary residence so important in our citizenship laws? Wait, I'll be reading this further. I want to point to one thing. If you see Article 5 of the Constitution of India, it uses the word domicile. At the commencement of the Constitution, every person who has his domicile in the territory of India. This is the significance of ordinary residence, permanent intention to permanently settle. My lord, even domicile is not a very well-defined concept. But taken from private international law, we know that domicile means the place where you reside with the intention of making it your home. That's the definition of domicile. And my lord, domicile, in fact, in this country has caused a lot of problems given the federal nature of the country. When it comes to things like admission to medical colleges, my lord, and states make reservations for people who are domiciled in their states, all those disputes have landed up in court. Whether any such preference can be given to domicile, and it remains, I think, an unresolved issue. But the reason I'm pointing to domicile is there are two running threads in the Constitution Part 2 and the Citizenship Act. One is the concept of permanent residence and intention to settle. And the other is persons of Indian origin. And here I would say Indian origin necessarily has to refer to undivided India, because Article 6 and 7 give them citizenship. So there's a running thread in the Constitution to give citizenship to persons of Indian origin. In fact, my lord, the demand, as your lordship knows now, is that NRIs and overseas citizens should be given citizenship, and the late Mr. L.N. Singh, we had agreed to this, after which we got the concept of long-term visas and overseas citizens, where the government now issues those cards. And currently, my lord, there are petitions pending before you, which talk about why we should not be allowed to have dual citizenship of different countries. Now, of course, I don't want to get into that issue. But what I want to emphasize, my lord, is that these are the two running threads. So 3 running threads. 1, the birthmark of partition. 2, the concept of giving citizenship to those who make their domicile in India. And 3, persons of Indian origin. Now, my lord, Article 6A satisfies all these 3 conditionalities in principle. Procedure, etc., is a different issue. But all these three conditionalities are satisfied by Article 6A.
These are the three conditionalities.
As Section 6A of the Citizenship Act, my lord, and therefore its constitutionality must be viewed in that context.
Which are the three conditionalities?
One is the relevance of the birthmark of partition in this country. The second is the intention to reside permanently in India. And the third is a person of Indian origin, India being defined as undivided. These are the three guiding principles for determining the constitutional validity of 6A. Has Parliament gone beyond these principles?
What
It
is
has
the
not.
second one, madam?
The second one, my lord, the second one is the intention to reside permanently or settle or resettle within the territory of India.
What is the third, brother? Third kya tha?
Person of Indian origin.
Yes, person.
So, my lord, when it comes to culture, I'll just conclude by saying, I'll just take you back to my written submissions to show you how notoriously vague the concept is. Now,
Actually, you know, if you really look at that, culture is such an amorphous concept. Culture is you can say in so many ways, a product. I was just identifying, you know, what goes into culture. You say Indian culture. Is there an Indian culture? And then, so all of us believe there is an Indian culture because we belong to this syncretic culture of the nation. But what is it? What goes into it? You can say language.
yes,
Not that your language is culture, but our relationship to our language is an equally a part of culture. You have your aphorisms, you have your colloquialisms. They go into sort of making up your culture.
Art, belief.
Language, customs. See, I've identified a few things: language, customs, social institutions.
yes, my lord.
Religion. Your religion.
Yes, yes, my lord, all of that.
Practices.
Yes, my lord, all
Food.
of that. So,
Food.
food,
Apparel.
yes,
Geographical conditions.
yes.
Relationship with nature.
Yeah.
For instance, you go up to Ladakh, you go to Zanskar, you'll realize that, you know, the culture is a product of your relationship with nature when you travel to those areas. Or you go down to, say, the west coast of Maharashtra, you'll see so much of use of coconut. Why? Because of the fact that coconuts grow there. You go down to Kerala. So even that's all, it all goes into the generation of a cultural tradition. So culture is not specific to any of these items, but is a unique, is an interplay of all this that produces a culture. Music has a very important bearing on the production of culture.
Respect to law and order.
It's a way of living.
Respect towards law. That's why in certain parts you see people are more into millets.
Well, Lord, with respect, I agree. All these elements make up culture, and it's an aspect of our identity. But, my lord, your lordship will also bear in mind that we self-identify with a particular culture. It's a self-identity with a particular culture. Nobody's forcing it on us. And, my lord, we cannot forget that this country was reorganized on linguistic lines by the States Reorganization Act. At the end of the day, my lord, the entire country was reorganized on linguistic lines because language is an important element of identity of a human being. This is the reason why it was reorganized on linguistic lines. So, and this is why language is protected, especially under Article 29, under the right to culture. Well, there have been so many language disputes in this country. Your lordship knows whether the three-language formula should be adopted, whether Hindi should be enforced on non-Hindi speaking states. The disputes are endless, but it's because there is so much identity with language. An individual identifies to such an extent with language that it's a separately protected right under the Constitution. So, my lord, I've gone on to explain that it's notoriously amorphous and it's a notoriously overbroad concept. And I have finally come to the conclusion, my lord, that judicially, your lordship can only accept constitutional culture, constitutional morality as the culture of every citizen of India, in addition to any other culture that they may have. Why has this court taken such pains to emphasize the issue of constitutional morality in this country? Because we are a secular country, my lord, and because every section of the citizens have their rights separately guaranteed. And my lord, insofar as religion is concerned, my lord raised religion as part of culture. It is separately protected under Article 25.
But everything that of this is separately protected.
Yes.
Your right to food is protected by 14. Language is protected independently.
Yes.
But culture is what emerges from this, the interplay between all these. It's
Yes.
a way of living, as Brother Sundaresh
But
said.
it's self-identity with the culture. Nobody can tell me you identify with somebody else's culture. We create our own cultural communities and we identify with them.
And there are subcultures as well. We all say that we have a culture as Indians. But we then also have culture. We have also a culture as belonging to the state where you come from,
Yes.
the area of the state where you come from.
So, my lord, that my conclusion, and I won't bother you with it, is that when this court is venturing to answer the question, if at all, what is culture, my lord, kindly bear in mind that we already have a constitutional culture in this country, built up through precedents of this court and through the very document that we are reading today. And I would say that it is that constitutional culture which cannot be endangered.
Thank you, Ms. Jason. Thank you
Yes,
so much.
my lord, one more, there are some questions that I need to answer. In the list of dates I've given, my lord, in fact, a very, very famous senior counsel of this court has migrated to India. In his autobiography, he records that he migrated from Burma to this country. So who is Indian, who is not? Who is Assamese? There is no definition of Assamese at all. We are only resident.
From Burma to India. To Assam.
And Assam was part of Burma, actually, and then ceded to India under a treaty with the Burmese. So, my lord, as Mr. Sybil had indicated, the cross-migration that has taken place in Assam includes Hindu, Muslim, Christian. A lot of the tribals are Christian, my lord, in the state of Assam. Those who have gone into the autonomous areas. Therefore, my lord, to present demography, my point is only this. I'll just read out one small paragraph. That to offer demographic data as evidence of impacting culture is not constitutionally acceptable. And I'll read it out I'll just give you the 3 reasons why. Because, my lord, the statistics don't tell you what were the causes of this demographic change. Now, my lord, what could be the causes of demographic change? I'll spell them out to the best of my knowledge. It could be, my lord, at the basic level, the argument expresses on the moves on the assumption that demographic profile has changed primarily on account of cross-border illegal migration. That's the argument. While an increase or decrease in demography may be on account of various factors like fertility rates, interstate migration, illegal migration, etc. The petitioners have not been able to demonstrate through any reliable data as to the cause of the alleged demographic change and the quantum of demographic change due to immigration. The only data that has been provided is the increased proportion of Muslims as compared to the average rate of growth of population in the state of Assam. But the data shows that the growth rate of Muslims is lesser than that of scheduled castes and scheduled tribes in those states. Also, growth rate of Muslims in Assam is lesser than in MP, Maharashtra, Haryana. That's merely because of average growth rate of the state does not. Yeah, last point. Yeah. Well, there's just one other issue, if I may seek your indulgence, which I need to address. References have been made to the fact that immigration is external aggression. This is, to say the least, my lord, an argument of alarm. In migration, my lord, could be on account of distress.
Sarbanan Sonowal said.
I am arguing, my lord, that that judgment requires to be overruled. Do it or don't do it, that's your option. But yes, if it's not an issue, fine. But I just want to put it on the, my lord, please, now please. It's in the very order of reference. No, my lord, Sonowal says that. Now, what are my reasons for not saying it, my lord? Article 352 of the Constitution of India, which talks about declaration of an emergency, uses the expression war, external aggression, or armed rebellion. Therefore, my lord, the word external aggression must be read justum generis with war.
But suppose a cyber attack is launched on one of our states. Government of India can say we are duty bound under Article 355
Of course,
to protect.
Lord, I don't deny that.
So external aggression today is a very broad, it could be a cyber attack, for instance.
But internal, I'm not talking about internal disturbance. Internal disturbance, obviously the union has a duty to protect every state from internal disturbance. I'm saying, can you refer to migration as external aggression? My answer is no. Now, one minute. My lord, in that very judgment, the criteria of whether it is external aggression or not is dependent on what is the animus belligerent. What is the animus of the person who is being aggressive is the touchstone to decide whether it's external aggression or not. If it's a belligerent intent, it is external aggression. Now, migration that has taken place, especially from the subcontinent, the undivided subcontinent, is a distress migration. It's a migration which has taken place, my lord, with the intention of finding safe harbor in India. You may not want them. In your sovereign right, you may want to get rid of them. But to describe them as aggressive.
You got your point. What you're saying is that people who have migrated have at the least come in search of a safe harbor, or they are fleeing external conditions of atrocities or violence. And therefore the attempt is not to destroy the Indian social fabric, but to protect their own way of living.
That is the touchstone for deciding whether it's external. And excuse me, it is in a black and white judgment of this court. And that's why it's my duty to address it, my lord. And my learned friend read it out specifically. These are arguments of alarm. And my lord, it is my respectful request to you to revisit that passage. In that very judgment, you'll find the touchstone of animus belligerence as the touchstone for deciding whether it is. And my lord, reference has been they have referred to a judgment of 1883 of the United States Supreme Court, where Chinese immigrants were turned back. Now, my lord, those statutes of the United States have been repealed, precisely because you cannot look at an immigrant as an aggressor. And finally, my lord, the judgments of the Supreme Court which have been relied on in that judgment were overturned in Trump versus Hawaii in 2018. Therefore, my lord, there is a case made out by me for you to revisit that passage. I don't say don't address the question of illegal immigration. That's not my case, my lord. All I'm saying is they cannot be described as aggressors, as it cannot be, the migration cannot be described as a form of external aggression. There may be so many remedies. And last, my lord, to answer the question raised by Justice Sundaresan, in the list of dates, there is an extant statute which was enacted in 1950, which talks about expelling people from Assam. Even that statute, it's at entry number 1950. It's known as the Immigrants Expulsion from Assam Act 1950. And it gives to the union the power to expel an immigrant from Assam. But my learned friend has also pointed it out. It makes an exception. If it's repealed, then I stand corrected. All right, I won't refer to it. But at the relevant time, my lord, it exempted people who came due to civil disturbance. That question was asked, how do you describe these people? That's why I'm addressing it.
Now, we are almost concluded on this side, almost, I said. Who else? Mr. Hegde is there, Malika is there, then.
Five minutes. I'll just take 3-4 minutes. I agree with the Assam Accord. I'm supporting the right Solicitor General. Just 3-4 minutes.
Well, Lord, just one note of
Point which are not.
Can we now just, can we suggest one thing?
Well, not-
Just one thing, Ms. Jason. Can we just suggest this? Let's get the order clear. Sanjay, Sanjay, just take it down. We'll first hear Mr. Sanjay Hegde.
Well, the written
Then
submissions
Mr.
are filed in sequence.
Then Mr.
They are in volume 2.
No, let's.
But tell us, we'll just put it down here. So,
Yeah, let's.
see, everybody knows who's first and who's next. Then,
I would have finished today itself. Yes, I won't take very long.
all right, then Mr. Sanjay Hegde, Mr. Anupam Lal Das, Mr. Mr. Yeah. Then Mr. Siv Singh,
Sir, myself also, Dr. Will.
and then, all right, then myself.
Lords, I'll take only 5 minutes because I have comprehensive written submissions. I'll just point the headings so that Lords in 5 minutes.
All of you are now going to follow, have filed the written submissions?
Yes.
Can we just suggest one thing? Can we just suggest one thing? Who's the nodal council?
Mr. Ayubi.
And
Diksha Rai is also here.
Right.
So what we'll do is, everyone, please put down your, whatever you want to say in not more than 1 page, bullet points. Give it to Diksha.
Yes.
So we will, Diksha, you put it in the order in which we have now mentioned. We will look at that 1 page bullet points to just take us through that in rapid fire so that we'll finish in about, at the outer limit, say half an hour. So, 11 o'clock, we will hand it over to Mr. Diwan, Mr. Chaudhary and Mr. Hansaria to make the rejoinder. We'll wrap up by lunch. So, but do make sure that all of you have that 1 page bullet point so that we know while dictating the judgment becomes very complex otherwise. We know then what exactly has been stressed by those who followed from the main council.
President Roosevelt used to say, if it's important enough, only one.
Oh, give me my, this thing calls list.
Have your lordship's permission, my lords, just wanted to know the lordship's pleasure regarding that Asia resurfacing, my lord, is it to follow or not?
Mr. Dwivedi, we are
Yes,
definitely taking HR resurfacing because it's a matter which is causing, there's quite some concern in our district judiciaries because.
So tomorrow your lordship will take it
follow
up?
the order of the High Court or the fact that
Yes,
there's an order of
that's
the
right.
Supreme Court.
That's right, my lord.
Because
You lordship will take it up tomorrow, my lord?
all stays will be deemed to be vacated after 6 months. So what we will do is, that's a
Yes.
different combination because I think Justice Oak and Justice Mithila join us. So
Yes.
perhaps if we finish this on Tuesday by lunch, or ideally let's begin after this gets over, instead of keeping it say Tuesday after lunch, suppose this spills over by 15 minutes, we can then keep it on Wednesday morning. I think that's much better. I don't think the whole matter should take more than an hour between you and the.
I appear for the state of UP. We can't take further.
Mr. Dwivedi, how long will you take?
Lord, half an hour, my lord.
All right. So Wednesday morning we'll keep it.
It can be taken also on Friday, my lord, if your lordship so finds convenient.
Friday will be miscellaneous,
Yes.
Let's do it on Wednesday so that, that
Yes.
1 hour we'll be there.
Yes, Your Lordship. All right.
And a
I
short
just
note
want to
maybe
point
on
out
the
that
website.
writ petition 274 is before a
Mr.
different
Dwivedi's
bench.
submissions have come, Mr. Solicitor, if you are giving something.
I shall file it by Monday, my lord.
Well, look, this first writ petition is actually being monitored by a different bench. So I just want to say that the judgment in this case, we hope will be confined only to constitutional validity because it covers a wide range of issues beyond constitutional validity. This writ petition 274. So the judgment will not
6A,
dispose of 274.
6A, and whatever we have passed an order, short order, where we want a disclosure by the Home Secretary.
Right.